number 25.
madam Tripathi paper bookta diyantu. So, Mr. Mishra, yesterday we have noted down your submission. When we asked you that what are the circumstantial evidence in this case, you said that prosecution has established that it's a case of homicidal death. That is also the finding of the London trial court, right? Then you said that there was dispute between the appellants and the deceased, and PW1 has stated about it. We pointed out some difference between the evidence of PW1 and PW2, right? Then you made the submission. The next circumstance is PW1 has seen the appellants leaving the place, and appellant number 1 was holding the axe, right? And PW5 and 6 do not notice the axe in the hand of any of the appellants, but they have also seen the appellants leaving the spot, right? So then you said that the next circumstance is the conduct of the accused persons in producing the axe before PW14 and making confession. And basically, these are the circumstances.
May I only submit one thing? Lord?
Yes, yes.
May I be permitted to withdraw that confession part?
Confessional statement I have also verified that has not been also relied upon on the ground of. I think there is some.
Yes, there is.
Yes, in page number, internal page is 12, and the running page is 18 of the judgment, where the London trial court has held that the confession made by both the accused persons in this instant case before the police staff, even if it is not admissible, the conduct part he has said that
yes,
weapon of assault. So, okay, that confessional part will should not mention this. So, about the conduct of the acts, conduct of the accused persons producing the acts in question. But again, we have said that that very acts was sent for chemical analysis and no blood was found. And most importantly, that acts was not shown to the person,
the person who had sent it.
PW1. So, acts was not shown to PW1 for the purpose of identification, right?
Yes, Lord.
Because perhaps no material object was produced on that day when PW1 was examined, because he made a statement that I am not
witnessing
this. So, while going through the evidence of PW14, yesterday I also find that he has not identified the appellants to be those two persons who came and like PW13, he has not stated. Look into that PW14's evidence at page 73. Read it once again. So that
excuse me. On 4/8/2004, I was attached to Harbanga police station as constable. On that day, I was on sentry duty. Both the officers had gone to Baud to attend crime meeting. On that day, at about 4 p.m., two persons arrived at the police station with a tangia and confessed before me that they have committed murder of a person and requested to save them. On my interrogation, they expressed that out of fear they had come to a distant place. I detained them and intimated Bada Babu over VHF. He directed me to detain both the persons in custody till his return. They were wearing lungi and gamucha. The lungis were stained with blood. The tangia was separated from the iron portion. I also entered the fact in the station diary, wide entry number 63, dated 4/8/2004. This is my signature thereon, already marked Exhibit 12 by 1. I have also made entry number 64, dated 4/8/2004. This is my signature thereon with the entry already marked as Exhibit 12 by 2. In the same night, at about 7:30 p.m., Bodobabu Judhishthira Behera arrived at the police station. At about 9 p.m., OIC Daspalla also reached there. OIC Daspalla seized the Tangia along with its handle on the same day at 9:30 p.m. in my presence and in presence of the Gramorakhi. This is the said Caesar list marked Exhibit 13, and this is my signature thereon, marked Exhibit 13 by 1. MO3 is the said Tangia iron portion which was separated at the time of Caesar. Now same is also separated. Cross examination. I'll read the.
First
He has
and
not
second
identified. I've
First and second line.
He committed the blunder, the defense counsel, because after this, the public prosecutor was required to put him in question that जो दी जन लोक आसीथिले सेमानकु कोर्ट रे देखुछ कि एई प्रश्न पचारिथिले से कहि थांता जे आज्ञा एई जो दी जन.
So that responsibility has been shared with the defense.
The defense has brought out that in the cross examination. But another thing you mark, he said that when he ascertained 2 to 3 lines thereafter, I kept the Tangia in the room of OIC and the accused persons in the Hajat. ये टाइम टा होची आपण देखंतु से आसिले कहउजंती 4टा बेले से दी जण लोक आसिले तापरे ये तांकू रखिदेला कोउठी ना हाजत रे रखिदेला टांगिया टाकू नेकिनी रखिदेला ये रे बर्तमान PW 13 रो एविडेंस को आसिला बेलू PW 13 रो क्रॉस एग्जामिनेशन देखंतु जे 2:10 रे मु जेतले पहुंचिली by that time accused persons were in Hajat and Tangia was kept in the room of the OIC. So obviously this man has not seen the arrival of PW 13, has not seen the arrival of the two accused persons in the police station. What he had seen them in the Hajat and that Tangia in the. He cannot be said to be also that witness to that confessional part. Confessional part jaha thila se
immediately
mane 14 ପାଖରେ ସରି ଯାଇଛି. ହଁ 14 ତାଙ୍କୁ ନେଇକିନି ହାଜତରେ ରଖି ଦେଇଛି ଟାଙ୍ଗିଆଟିକୁ ଆଣିକିନି OIC ର ଇଏରେ ରୁମ ରେ ରଖିଛି ଯୋଉଟା କି 7ଟା ବେଳେ ସିଜ୍ ହେଇଛି ବୋଲି କହୁଛନ୍ତି. ତେଣୁ so now let us summarize. ଆମେ ଯେତିକି evidence ଆସିଲା ଯଦି previous enmity ର କିଛି clinching evidence ନାହିଁ ଯୋଉଟା ଆସୁଛି so ବାକି ରହିଲା ଯେ accused persons decamping from the spot and of course one of the witness has stated PW1 to be holding a tangia, right? And next circumstance is production of one tangia by the accused persons. आउटाकू सेटाकू जदी काटी दिया जाए से कन्फेशनल स्टेटमेंट एई दीटा सर्कमस्टांस रहउची आ छडा आउ कोन होमिसाइडल डेथ इट्स ऑल राइट एई दीटा सर्कमस्टांस रे कैन यू जस्टिफाई that is our that the chain is so complete that it unerringly point towards the guilt of the accused subject to what you say. आउ किछि सबमिशन आउ किछि at least देखा जाउनी माने decamping, one person saying holding and if previous dispute is deleted বা কাটি দিয়া যায় তাহলে next circumstance হচ্ছে appearance in that
Police
another
station.
police station with one tangia ଏତିକି ରହୁଛି ଇଏ. What is your submission?
But my submission is that the chain is complete, because now even if we take out two circumstances which I submitted yesterday, that is the second and the fifth one, which I've already withdrawn the fifth one. So even if your lordship disbelieves the second circumstance, circumstance number one still remains that it was a clearly homicidal death. That was a very
Homicidal death,
brutal in nature. And immediately after the occurrence, PW 1, 5, and 6 have seen both the accused persons present there. PW 5 and 6 have seen them going
So
away.
it is a preemption or it is a link
It's a link, your lordship. In my
vis-a-vis the
submission,
murder.
in my humble submission, it's a link because they were seen at the spot immediately after the
Is it unnatural to see them in the courtyard? Is it
Yes,
unnatural?
they were not residing there.
No,
They
no.
were living
ଆପଣ ସେଇ
separately.
ଆପଣ ଚିନ୍ତା କରନ୍ତୁ, just let us think. ଗୋଟେ ଡେଡ୍ ବଡି ସେ ଘରେ ପଡିଛି, ତ କିଛି ଦିଟା ଲୋକ ସେ ରୁମ ରୁ ତ ନୁହେଁ, ମାନେ
ନା ନା
କୋର୍ଟୟାର୍ଡ ରୁ ମାନେ ବାହାରିକି ଚାଲି ଯାଉଛନ୍ତି ହେଲା. ଜଣେ ତା ଦେହରୁ ଜଣେ ଟାଙ୍ଗିଆ ଧରିଥିଲା ବୋଲି ଗୋଟେ ଲୋକ
utterance could have been fatal. Utterance probably would have brought some link into it, because they made the others scared not to come, because they have immediately committed the murder. But that is not proved.
ନା. ଆଉ ବାକି ଆଉ କିଛି ଲିଙ୍କ ନାହିଁ, ମାନେ ବାକି ରହିଲା ସେଇ ଯୋଉ ସେଠି ନେଇକିନି ପ୍ରଡ୍ୟୁସ କରିବା, ଏବଂ ଯୋଉଟା କି କନେକ୍ଟ କରିଥାନ୍ତା, ଆପଣ କରିପାରିଥାନ୍ତେ ଯଦି ପ୍ରସିକ୍ୟୁଟର ଏଇଟା ଆଣିଥାନ୍ତା ସେଇ ଯୋଉ ଇଏଠୁ, ସେଇଟା ଗୋଟେ ଲିଙ୍କ ହେଇଥାନ୍ତା ଯେ ଏଇ ଇଏଟା ଦେଖିଥିଲା ବୋଲି, ସେଇଟାକୁ ନାହିଁ. ଏବଂ ଇନ ଆଡିସନ ଟୁ ଦ୍ୟାଟ ସେଇ ଯୋଉ ରକ୍ତ ନାହିଁ, ସେମାନେ ଇମିଡିଏଟଲି ସେମ ଡେ ମାନେ ପ୍ରଡ୍ୟୁସ କରୁଛନ୍ତି, ତାକୁ ଯଦି ସିଲ୍ କଣ୍ଡିସନରେ ରଖା ହେଲା ପଠା ହେଲା, ରକ୍ତ ନାହିଁ, ମେ ବି ଦ୍ୟାଟ ୱାଜ ନଟ ୟୁଜଡ ଅଲସୋ. ଇନଫରେନ୍ସ କଣ ଆସିବ ଯେ that was not used? ये doctor evidence होची, it is possible, it's all right, but maybe that tangia was not used. So कारण जो टाइप रो ब्लो दिया ହେଇଛି ତାକୁ, ସେ ବ୍ଲୋ ମାରିଲା ମାନେ ରକ୍ତ ବାହାରିବ, ମାନେ ଗଳା, ମାନେ ଯୋଉ ପୋର୍ସନ ରେ ମାଡ ସବୁ ହେଇଛି, ବ୍ଲଡ ଭେସଲ୍ସ, ସେଇଥିପାଇଁ ସେ କହୁଛନ୍ତି କୋର୍ଟ ରେ ଇଏ ଅଛି, ଇଏ ଅଛି, କୋର୍ଟ ରେ ବି ରକ୍ତ ପଡିଛି, ସେ ଘରେ ବି ସେ ଯୋଉ ଟାଙ୍ଗିଆରେ ରକ୍ତ ଲାଗିଥିଲା, ସେଗୁଡା ସବୁ ଅଛି. ବଟ ଏଇ ଯୋଉ ପର୍ଟିକୁଲାର ଟାଙ୍ଗିଆ ଟା ଯୋଉଟା କି ଏମାନେ ନେଇ ପ୍ରଡ୍ୟୁସ କଲେ, ତେଣୁ ତା ଦେହରେ ଏତିକି ଦିଟା ସର୍କମଷ୍ଟାନ୍ସ ରେ କିଛି decision ଆଣିଛନ୍ତି.
Yes, on reliability of the evidences of 1, 5, and 6, your lordship. Only on that point I've got decision.
We what my esteemed brother pointed out, let us that we accept that. We are accepting they are evident that they have seen the accused persons leaving the courtyard. ହେଲା, ଆପଣ ଦେଖନ୍ତୁ ଚିଫ ରେ ଯଦିଓ ସିଏ କହିଲା ଯେ ଆମେ ମୁଁ ତାକୁ ଡୋର ପାଖରେ ଦେଖିଲି, you come to PW1, chief ରେ paragraph number 2 ରେ ଦେଖିଲି,
but I also said that
paragraph number 2 ରେ page 42 ରେ second line, PW1 evidence, I found both the accused persons near the door of my house and they were saying to cause the assault to anybody, au kiye asucho aso hani debu. Now you come just to the cross examination portion, page 43 in the top. I heard the accused person saying kiye asucho aso, hela, from this hala. I found Purushottam was wearing lungi. Purushottam is appellant number 1, hela, but I cannot say what Karna was wearing. When we reached at the spot, both the accused persons fled away, and at a distance of 50 yards I saw the accused persons fled away. तामाने तांको दूरताटा थिला 50 फुट रु से देखिला पळै जाउचंती, हला. तेणु ये जो डोर पाखरे तांको देखिला, that also becomes doubtful, apart from the जो कोन हाणी देवी ना कोन सेटा, जदिओ चीफ रे कहला खाली मु सुनिली आउ की आसुचो हाणी देवी, किंतु एठी कहूची की आसुचो आसो, that is some kind of way. तेणु if we accept what has been pointed out you, that let us accept that the prosecution has successfully proved that the accused persons were
Have seen.
leaving
Yes.
the courtyard. So ସେତିକି circumstance ଏବଂ one of them, let us ସେଇଟାକୁ ମଧ୍ୟ accept କରାଯାଉ ଯେ one of them was holding a ଟାଙ୍ଗିଆ, ଆଉ ସେଇ ଗୋଟେ ଟାଙ୍ଗିଆକୁ ଆଣିକିନି ପ୍ରଡ୍ୟୁସ କରିଛନ୍ତି। ଏତିକି ଇଏରୁ can you say that the
They are the
perpetrators of crime जो चेन जो पांचटा प्रिंसिपल को नेले शरद ब्रिचान सारदारे जे कोनोसी सर्कमस्टांस को अन्य कोनोसी हाइपोथेसिस रे एक्सप्लेन करि होनथिबो हला सी एक्सप्लेन करिसेंती ना इट इज इमेटेरियल हाइपोथेसिस रे कोनोसी प्रकार एक्सप्लेन नै करने होनथि गोटे एवं सेटा कोजेंटली एस्टाब्लिश्ड हेथिबो। द्वितीयटा हबो जे एई जो सर्कमस्टांस गुडा को 1 2 3 4 जहा भी नबो सेटा गोटे एमिति चेन फॉर्म करूथिबो जादिरु किछि एस्केप भी करि परिबोनी जे नाइ या छडा आउ किए करिथिबो बोली कोनोसी मटेरियल आसनथिबो ताले ही जाइकिनी बाकी दोस डिसिजंस आर दैट जो मे बी and might be
Yes.
ta bhitere बहुत ocean of difference there are decisions how there are also decisions that heinous the crime higher must be the proof that is also the ତେଣୁ ଏଠି ଏତିକି evidence ରେ we are again asking you that how do you say that the prosecution has through these two circumstances and another additional say that it's a homicidal death it has been established successfully that it is the accused persons, these two accused persons, and none else who are the perpetrators of the crime.
Lords, their conduct has also to be taken into complete consideration and with full focus, because that plays a part to string all the circumstances, your lordship, to make the chain complete. Because they themselves going and submitting, even if we completely take out the confession part, they themselves going and submitting themselves before the police and producing that acts. Because we cannot just take out the fact that the act
No, no,
was
submitting man, let us say semane asile थाना कुछ पळे आसिले थाना को पळे आसी गोटे आक्स मध्यम प्रोड्यूस करले तो जी थाना को आसीबो गोटे आक्स प्रोड्यूस कर जीवो सी हे जीवो ऑथर ऑफ द क्राइम
if both
आपण एक्सक्लूड आपण जस्ट ये कोन सेटा को एक्सक्लूड कर देलु हमें 25 टा को आक्स रे आपणकर नाही ये रक्त नाही तांको वेयरिंग अपैरल्स रे रक्त नाही से आक्स से माने सेही पर्टिकुलर आक्स टा स्पॉट रे धरिथिले बेली आपणकर एविडेंस नाही कारण PW1 आइडेंटिफाई कला नाही ताहले दीटा लोक बा दी जण अपेलेंट गोटे थाना रे आसिकिनी गोटे आक्स प्रोड्यूस करले ऑन ए पर्टिकुलर डे कैन फ्रॉम दैट इट विल बी सेड दैट आउ गोटे गाँ रे बा तांको गाँ रे बा जोठी हो सेठी गोटे हत्या आइतला से माने
in itself it cannot be stated, your lordship, but combined with the versions of
सेत पई कहूछु जे सेत पई तो से डिसीजन टा हिची चेन गुडार को कंप्लीट हे जिवा
yes,
कंप्लीट न हेले आपण जदी कोनोसी मिसिंग लिंक रहला ना ताले ब्रेक करी गला चेन।
my humble submission is that because PW1, 5 and 6 have seen them, that will make the link complete, your lordship, because we are not reading that part. I mean, we're not I'm not justifying that
I would hypothesis I'm giving you an example गोटे घरे डेड बॉडी पड़ची हला जणे पसी गला देखिला जे डेड पार्टी सुनला सी भी आसिला अन्य मानक भली सी देखिला डेड बॉडी टा पड़ची तेणु काले किए ताऊ कोन करियो जदी सी दौड़ी की पळौतला एही सर्कमस्टांस रे ताकू जणे देखि देला जे से घरु बाहरी किनी दौड़ी की पळै जाउची तो कैन इट बी सेड दैट ही इज द एही एती अछि आउ किछ नै कैन इट तो सेहित पई कहूची काई माने हाइपोथेसिस रे एक्सप्लेन हेई पारुची कि नै देखिबो whether he has stated anything in accused statement that is not whether their language is very clear whether it can be explained under any other hypothesis or not ताले तो जीए से घरु माने गोटे स्पॉट रु दौड़ी किनी पळै जाउथिबो के जाइथिबो माने गोटे डेड बॉडी पळची गोटे जागा रे हला जणे लोक जाउची कॉल ऑफ नेचर अटेंड करियो सी देखि देला जे डेड बॉडी सो भयभीत हो गला पड़ी डेड बॉडी ये टांगियाटा पड़ी एग्जांपल दो तो सी दौड़ी पर एई समय आउ जणे लोक देखिदेला जे स्पॉट रू ये दौड़ी पड़े. So can it, from that circumstance, it be said that he is the author of the?
Lordship, in this case, if we believe the version of PW1, that he was holding an axe at the time, Your Lordship. So one of the accused person was holding an axe. One axe was already lying there, and the two accused persons were going away.
Now you are stretching to a different level.
Because he was seen with an axe, my lords. That is my submission.
डिसिजन अच्छी जेते जणे जेते इंटेलिजेंट हबो जेते ये करिवो से कोन करिवो ना से जो मिसिंग लिंक थिवो से ताकू क्रिएट करे दबो करिकिन से मिसिंग लिंक गुडा को फिल करे दबो माने पूर्ण कर दबो जो गैप टा रहिबा कथा तमे नाइ जे एमती माने सरमाइज एंड सपोजिशन एगुडा को मे बी ट्रू ता या भीतर बहुत डिफरेंस सेतपई से कंसिस्टेंटली ए जो डिसिशंस गुडा को कहउछंती जे सेही प्रिंसिपल पंचशील जोटा कुहाई जे ताकू yesterday also my esteemed brother has wrote that judgment and same principle it is still in there are 84 ro decision we are in 2023 से principle को follow ही चलिछ तापरे so many cases have been टिके आउ ताकू different angle चिंता करूछंती जो may be true my एगुडा को सब but the principle remains the same that हमको एई पांचटा गाइडलाइन को देखियो पड़िबो circumstantial evidence.
But the fact, Your Lordship,
what always you to find it. By the way, आपन को citations
citations on reliability of evidence of PW 1516.
हाँ हाँ या citations तबा कथा दे दूँ और next matter डाकुन से मैडम को फोन नंबर अच्छी की हाँ कांटेक्ट करूँ आइटम नंबर 1 थिला केंती आसुना हाँ जी अच्छों जी डाकुन
Item number 28.
Present application conviction for the office of physical two for utility for language. Fine of 2000.
এটা দিয়ে
My lord.
just पेपर उठा दे Your one person face trial.
Yes, so right.
Okay, 11 Kerketa. And the offense is 302. And name of the deceased is Lodha Khadia. Okay. And weapon of assault is Lathi, right? That we find from the first page of the judgment. Okay, please come to the FIR. Let's see. It's a case of direct evidence or circumstantial evidence?
This one PW 80 times.
Okay,
All
right.
PW 3 is informant, but he must stand.
Okay.
Also eyewitness.
All right, you first place the FIR, then we'll go to the
Case
here.
और नाम अनुप कुमार सिंह
कितने नंबर साखी
Case 20.
अरे कितने नंबर साखी अनुप
PW
कुमार
3.
ओके हाँ
Hostile.
ठीक है जी पढ़ जानते
मोर नाम अनुप कुमार सिंह बयस 34 वर्ष संसो आदि तारीख 2/1/2001 एक रात्रि 7:30 मिनिट समय आमर बस्ती रे उदित नगर फांडी पुलिस ऑफिसर पाखरे हाजर होई एई मौखिक एतला देव अछि कि मु आज को प्राय 10 वर्ष हला गुटे घरे घर करी मोर पिला छुआ सहर होउची मोर घर पाखरे लोधा खटिया घर करी रहिछि आज रात्रि प्राय 7टा समय मु घरे थिबा समय हठात लोधा खटिया घरे
Lodha is the deceased, right?
Yes.
हाँ हाँ
घे घे
ମାଡ଼ ମାରିବା ଆବାଜ ଶୁଣିଲି ଓ ଲୋଧା ଖଡ଼ିଆ ମାକୁ ମରିଗଲି ବୋଲି ପାଟି କଲା। ଏହା ଶୁଣି ମୁଁ ଦୌଡ଼ି କରି ଲୋଧା ଖଡ଼ିଆ ଘରକୁ ଗଲି ଓ ଯାଇ ଦେଖିଲି ଆମ ବସ୍ତିର ଲେଭେନ କାକାଟା ଗୋଟିଏ ବାଡ଼ିରେ ଲୋଧା ଖଡ଼ିଆକୁ ଜୋରରେ ପିଟୁଛି।
अच्छा
ଲେଭେନ କାକାଟାଙ୍କ ସ୍ତ୍ରୀ ତାର ଥିଲା। କାକାଟା ମଧ୍ୟ ଉକ୍ତ ସମୟରେ ଲୋଧା ଘରେ ଥିଲେ। କାହିଁକି ମାଡ଼ ମାରୁଛି ବୋଲି ପଚାରିବାରୁ ଲେଭେନ କାକାଟା କହିଲେ ଯେ ତାଙ୍କ ସ୍ତ୍ରୀ ତାର ଥିଲା କାକାଟା ସହିତ ଲୋଧା ଖଡ଼ିଆ ଗୋଟିଏ ଘରେ ପଶି କଥା ହଉଥିଲେ ଓ ତାର ସ୍ତ୍ରୀକୁ ଲୋଧା ସଙ୍ଗରେ ଦେଖି ସେ ତାର ସ୍ତ୍ରୀ ସହିତ ଲୋଧାର ଖରାପ ସମ୍ପର୍କ ଥିବା ସନ୍ଦେହ କରି ଜୀବନ ମାରିଦେବାର ଉଦ୍ଦେଶ୍ୟରେ ଖୁବ୍ ଜୋରରେ ମାଡ଼ ମାରିଛି। ଏହି ସମୟରେ ଲେଭେନ କାକାଟା ମଧ୍ୟ ତାର ସ୍ତ୍ରୀକୁ ସେଇ ବାଡ଼ିରେ ପିଟିଛି। ତାର ମାଡ଼ ଯୋଗୁ ଲୋଧା ଖଡ଼ିଆ ତାର ମୁଣ୍ଡ ମୁହଁ ଗୋଡ଼ରେ ଗୁରୁତର ଆଘାତ ହେଇଛି। ତାର ଶିଲା କାକାଟାଙ୍କ ହାତରେ ଆଘାତ ହେଇଛି। ଏହି ଘଟଣା ଦେଖି ଅଧିକ
तार शिला क्रिकेट किए नहीं माने पीडब्ल्यू कितने नंबर
वन
पीडब्ल्यू 1 ओके
होस्टाइल
अच्छा हाँ
ଅଧିକ ମାଡ଼ ମାରିବାରୁ ଲେଭେନ କାକାଟାକୁ ମୁଁ କହି ସେଇ ଘଟଣାସ୍ଥଳରେ ଅଧିକ ଗଣ୍ଡ ନ କହିବାକୁ ଜଗି ରହିଲି। ଲେଭେନ କାକାଟା ଲୋଧା ଖଡ଼ିଆକୁ ଜୀବନରେ ମାରିବାକୁ ଉତ୍ତମ କରି ଏପରି ଭାବରେ ମାଡ଼ ମାରି ଗୁରୁତର ଆଘାତ କରିଛି। After the
Okay.
was taken to hospital and
FIR logged on 307.
हाँ
Thereafter he died. Turn to 302.
so you come one by one just let us कारण एउटा hostile तो सब ହେଇଛନ୍ତି one is hostile
Hostile.
she
Wife of
is the wife of the appellant right
Yes. Not appellant, deceased.
deceased wife of deceased
no wife
Yes, one turn no.
wife of this wife of appellant
wife of appellant
ना.
right ସେ ବା ନିଜ ସ୍ତ୍ରୀକୁ ଦେଖିଲା ବେଳେ wife of
That is
appellant
how she is hostile. Yes.
PWT is the seizure.
sample earth blood stain earth okay
but I do not know what has been written in the seizure list and it was
काट दियो तापर
three informant to hostile.
hostile अच्छा
Informant is a neighbor.
yes
okay
Wife of informant.
PW4
Yes.
अच्छा कौन से कोयला don't know अच्छा then 5
PW5 is the assistant surgeon of government.
That who nail clipping and
collected blood sample
sample. Yes.
okay
That's
6
also
hostile.
7 nothing
7.
don't know the accused standing in the
I don't know.
so main witness is
Eight.
PW8
Yes.
please
I know the accused standing in the dock. My son Lodha died at about 2 years back. Wife of accused sat near my son in my house. At
so
that time,
this man is the father of the deceased my son kouchi pra
Yes.
Mama.
Mother. Iramani mother.
oh acha mother of
Mother.
all right mother of deceased हाँ ठीक है
At that time, accused came there and gave lathi blow to his wife and she left the place. Thereafter, the accused assaulted my son on his head by means of lathi and my son died subsequently in the hospital. My son had sustained severe head injury due to assault
On his
head. I was alone
Present.
at the time in his house and I have seen the occurrence. My injured son shouted, I also raised halla. Though I raised halla, nobody turned up. Then accused escaped. Subsequently, police came to my house and asked me about this case. My son was removed to Ralphala Government Hospital for his treatment. proceedings. Due to New Year occasion, there had been arrangement of handia and hen for being taken by us, and also there was an arrangement in the house of the accused. The house of accused is situated at a distance of 20 to 25 cubits from the house of the deceased son. We enjoyed drinks and food throughout the day in the evening. Accused had come to our house on Tuesday to take handia with us. And a debris
was burning.
burning in my house, and surrounding was dark. We were taking our food
in the veranda,
Either in the veranda
either
or in the house.
in the house. The eating was done. Balu Ghat in the house of my younger son. After fooding was over in the evening, accused left from the house of my son. Then my younger son slept. In Tuesday morning, we came from Balu Ghat to Sitalpada. On that day evening, the incident took place at Sitalpada house. It is not a fact that on Tuesday evening, accused did not come to my house at Sitalpada. On the date of occurrence, I have told the incident to police being asked by police. It is not a fact that accused has not assaulted my son. It is not a fact that I am deposing against the accused on
Guesswork.
crossfire. And recall also further matter.
Further examination.
Further.
Ah.
I have seen the assault on my son. Myself and my deceased son were alone in house. None else were there.
Was there in the
PW9. PW9 is the scientific.
Yes.
PW9 is a scientific.
Mm.
On 30
3-1-2-1.
2008, I was scientific officer
DFSL roll call.
on the date of police requisition. I, along with my team, visited at the spot. The spot in this case was bedroom kitchen room of the house of the deceased Lodha Khadia, situated at Sitalpada, Raulkela. Inside the room, that
palm
with two kanthas were found spread on the
Floor.
floor of the room. The kantha were found laying in a disturbed manner. On of these kantha was found extensively stained with blood. Some broken pieces of the glass bangles of and color was found laying on the mat as well as on the floor. Some pieces of the brass with one of the piece having blood stain was found laying in the mat. These pieces seems to have been dislodged from the lathi used from assaulted the deceased and the victim. Blood stains were found on the mat and earthen floor below the mat.
This is the bangles means might be that assault. That means let us just visualize the situation. That means he found the
His
this
wife.
lady, his wife,
Yes.
in the company
of that deceased.
deceased in the bedroom of the deceased.
That's it.
Okay.
Letter of blood were also found on the western and southern wall of the room. The height of 4 feet and 2.5 feet respectively. The photograph of the dead body was Lodha photo was taken by the RGH Royal Kala during spot visit. The following clue materials have been collected. First one,
Dirty.
the printed kontha have been blood stained marked as a B. Second, blood stain, earth and sample are marked as A and A1 by A1 respectively. 3. 6 broken pieces of
Maroon and blue color.
blue colors slash bengals marked as exhibit 6. Some broken pieces marks 1 have been blood stain marked as a D. The preliminary examination reveals presence of the blood stain A, B, C, and D. All the material exhibits were separately parked and part leveled and handed over to the IO to the spot uh, with the instruction to send this exhibit to Director
SFL.
SL Bhubaneswar for biological and serological examination and open. This is my report as a 3 and exhibit 3/1 is my signature. Cross examination. At 11:30 a.m., I visited this spot. Before spot, I have gone to Raulkela Government Hospital. I collected blood sample from the floor and not from the wall. I have not taken photograph of the scene of crime. I have not examined the lathi seized in this case. I have also taken the photograph of
The deceased.
at RGS Raulkela on 3/8/2008. It is after 1:30 p.m. only, though I have not specially mentioned the time.
Who is the doctor conducted?
Not examined.
Not examined.
And what is the who has proved that report?
That is absent in that.
कौन पोस्टमार्टम
हाँ।
रिपोर्ट भी प्रमाण ही नहीं
H, exhibit 15.
It's a mere exhibition.
I don't know.
तो
I don't know who is maybe.
ना ना किए प्रमाण कर आपण तो किए उठा ताको ये तो competent person is the doctor.
Doctor.
Yes.
So if he has not proved it, then how it was proved? आयो कोड तो नहीं सेठी
आयो रे नहीं. आयो कोई नहीं. ठीक है देखिए. ठीक है मुझे तो जान पर पूजी का उनको ये consider.
How many days after the occurrence he died?
3/1/11.
3/1/11 he died.
2001.
That means next day.
Next.
Who has stated that? PW9. PW9 the scientific officer से किंतु कोई हो. तो माँ को जी ये PW8 को जी subsequently died.
Yes.
So जैसे subsequently टा के बे.
Postmortem against no head 4/1.
हाँ ना.
4/1.
कौन पाई मैंने एग्जामिन वाला नहीं जो ऑर्डर सीट रे कुछ मेंशन नहीं. First of all, when that was marked as an exhibit, And why? Whether the doctor was dead or he was not available in spite of repeated summons, he did not appear or what? PM report is
15 exhibit.
Exhibit 15, but who has marked it? Because it can't be marked under section 239 CRPC.
exhibit 15 କାହିଁ ଯେତେ list ରେ କାହିଁ ପାଉନି ହଁ ହେତେ ଏ ଯୋଉ list ଗୋଟେ ଅଛି ମୁଁ ସେଠି ଟ୍ରାଏଲ କୋର୍ଟର list ରେ LCR ରେ ଦେଲ ମତେ କପି ଇଏଟା ଦେଲ
Page 70, page 19
ଜଜମେଣ୍ଟ ତ ଅଛି ସେଟା ଯେ କିଏ ତାକୁ ମାର୍କ କଲା ଅର୍ଡର ସିଟ୍ ରେ କେବେ
there is an exhibit list maintained that is list of exhibits ମଧ୍ୟ ଆମର ଏଠି ଅଛି but ସେୟାରେ exhibit 10/2 ପର୍ଯ୍ୟନ୍ତ ଅଛି ତା ଦେହରେ ଇଏ ଅଧା କରୁଛନ୍ତି ଅଧା ଛାଡି ଦଉଛନ୍ତି
On that day, IO was exam.
ଆଇର ତ ଡିପୋଜିସନ କିଛି ନାହିଁ
ଇଏଟା କାହିଁ ଅରିଜିନାଲ LCR ଗୁଡାକ ଆଣୁନାହାନ୍ତି ଇଏ ଜେରକ୍ସ କଲା ବେଳେ ମିସ୍ କରିଛନ୍ତି ବୋଧେ ଏଇ ଯୋଉ exhibit 10/2 ପର୍ଯ୍ୟନ୍ତ ଏଇ ପେଜରେ ଅଛି ତାପରେ ଏଠି ଆରମ୍ଭ ହେଇଗଲା ଇଏ ଛାଡି ଦେଇଛନ୍ତି ଡେଟ୍ ରେ କେମିତି ମାର୍କ ହେଲା ଜଣା ପଡିବ ଆଗରୁ ଅର୍ଡର ସିଟ୍ ରେ ଲେଖା ହେଇଛି
ଅର୍ଡର ସିଟ୍
ଏଇଟା ହେଇଛି 14/3/2008 ରେ ଗୁଡାକ ମାର୍କ ହେଇଛି ତାପରେ ହେଇଥିବ କେତେ
IO was examined, but documents such as Exhibit 10, 11, 12, 13, 14. This much.
ତାପରେ ଲେଖା ହେଇଛି at this stage the State Defense Council files a memo that he admits the
PM
PM
report.
report. In view of the
admission.
memo
On
filed on
admission.
On admission.
Yes.
Acha.
On admission, it is marked. Yes.
So
89 Supreme Court. Yes.
now postmortem report ର finding କଣ ଆସୁଛି ମାନେ କେତେଟା ମାଡ ହେଇଛି କଣ ହେଇଛି ତାକୁ
ଏଇଟା କିଛି ଏଇଟା
ନାଇଁ ତା ଦେହରେ କିଛି ନାହିଁ ଆମେ we are looking at the PM report. As we find that body of the male so average build person multiple injuries on the so ଆଚ୍ଛା ହଁ injury ଗୁଡାକ describe ହେଇଛି ଗୋଟେ ହଉଛି lacerated wound on the right shoulder so and so next wound is lacerated wound below left कौन होता लिखा है जी अच्छा नी लिखा है okay you are right ठीक
Steve.
2E circular abrasions near elbow external aspect about 2 cm in diameter so and so lacerated wound on the right side forehead that is 3 cm 2 cm above so and so then linear fracture 4 inch in length on the frontal bone below the above so and so Individually, all the injuries were antemortem in nature. Age of the injury were about so and so. Death was due to injury to the vital structure, that is the brain. Death occurred within so and so hours. Blood and so and so collected. And viscera collected. Okay. So cause of death was due to the that head injury, that brain injury. So how far you have succeeded in demolishing the evidence of the solitary witness, who is none else than the mother of the deceased? Why will disbelieve her evidence? हाँ कौन है ओहो जी होस्टाइल ହେଇଛନ୍ତି ତାଙ୍କ କଥା କାଇଁ ଆମେ କଣ ପ୍ରଶ୍ନଟା ପଚାରୁଛୁ ଏ କେସ୍ ରେ ସଲିଟାରୀ ୱିଟନେସ୍ ଅଫ ଦି ଷ୍ଟାର ୱିଟନେସ୍ ଯଦି କୁହାଯିବ ତାହେଲେ ସିଏ ହଉଛନ୍ତି PW8 PW8 ର ଆପଣ ଏଭିଡେନ୍ସ ପ୍ଲେସ୍ କଲେ what is your submission on PW8 as to why that witness, who is the none else than the mother of the deceased, is to be disbelieved?
He denied the presence of the PW3 and 1. But the PW1 and 3 present in the spot as per the actor, as per actor. And another thing that the operative place on the previous moment, the appellant and the wife of the appellant, and this is sitting in the one. That is the occurrence. That is the fact.
So you mean to say that looking his wife in the bedroom of the deceased, that caused the grave and sudden provocation, and on a spur of moment he assaulted. One blow has been given, but that has caused fracture of the frontal bone, and that has also affected the brain. That is why the doctor has stated that. Other parts, au jo injury gudaka achi elbow felbow re, that was not, but head injury ta lathi re ye hoichi.
Spur of moment in the suspected illicit relation between the wife of with wife.
ସ୍ତ୍ରୀ କୁ ବି ବାଡେଇଛି ସେଠି ଯାହା ଜଣା ପଡୁଛି, କାରଣ କାଚ ଗୁଡାକ ଭାଙ୍ଗି, କାରଣ ମା ବି ତାର କହୁଛି ଯେ ତା ସ୍ତ୍ରୀ ଥିଲା, ମାନେ ହଁ, she was present in the bedroom of his son. That is the evidence of PW8. The wife of the accused sat near my son in the house. Acha, तो सेही पोजिशन रे सी आसिकिनी देखिछि, बेडरूम भितरे तार स्त्री आ पाखरे बसथिला, सो सेईटाकू से देखि जाइछि, स्त्री को भी बाड़ैछि आ आकू बाड़ैछि. No, that is they are tribal people. They at a cool area case.
Sundargarh.
No.
Sitalpada. No, it was a festive season, I think, or semane
New Year.
Oh, New Year celebration. Okay. Ma kohuni ne jame aschilu free of people na konandi. We are taking food on this one. So after the eating was over, so and so after the food was over, evening after left the house, and on Tuesday morning we came to so and so. On that day evening, the incident took place at Sital, but it's not our. We did not come to the house. କେତେ ବର୍ଷ ରହିଲାଣି? 2008 ରୁ? No, ଆଚ୍ଛା ଇନସିଡେଣ୍ଟ ହେଇଛି 2001 ରୁ. So
22 ବର୍ଷ.
ବେଲ୍ ରେ ଏବେ ହାଇକୋର୍ଟ ରେ ହେଇଥିବ, ଟ୍ରାଏଲ କୋର୍ଟ ରେ କଣ ବେଲ୍ ରେ ଥିଲା? ଟ୍ରାଏଲ କୋର୍ଟ ରେ ବେଲ୍ ରେ ଥିଲା, ପ୍ରେଜେଣ୍ଟ ହାଜିରା ଫାଇଲ ଲେଖା ହେଇଛି. So କେବେ ଫାଷ୍ଟ କଷ୍ଟଡି ସେ କେବେ ଗଲା? No, forwarded on 512K. 5/1/2001. Then देखो जी 2/7/2001 बड़ू कस्टडी रे थिला।
He was released on bail on 14/8/2001.
अच्छा 14/8
To go on bail.
हाँ 2001 तामाने पाखापाखी ହେଲା 7 ମାସ ହେଲା ସେତେବେଳେ। ତାପରେ କନଭିକ୍ସନ ସେଟା କଣ୍ଟିନ୍ୟୁ କଲା ନା ଆଉ ଭିତରେ ପଶିଛି? accused is present, absent, ହାଜିରା।
No, accused is not produced.
हाँ अच्छा हाँ ପୁଣି କହୁଛି ପ୍ରୋଡ୍ୟୁସ ହେଇନି ତାମାନେ ପୁଣି ବୋଧେ
produced ଅଛି।
ସିଏ କଷ୍ଟଡି ତାମାନେ ପୁଣି
ଯାଇନି ତାହେଲେ। He was
नहीं he was on bail, then perhaps he was that is the order dated NBW was issued. He was absent continuously, for which NBW was issued as it appears from the orders in 2005-06 onwards. नहीं प्राय defense counsel file is so and so. Our prayer is allowed from accused is present. Accused is present. 2000 accused is present. Accused in no step taken. So NBW issued on 27/9/2004. 27/9/2004 NBW issued, and he was arrested and produced in court चौदह 15/2/2008 बेलर आसिकला मु प्रोड्यूस करिवे। ओके
19/2/2008 19/2/2008
तुमके बेलर इज प्रेजेंट
18 की
नहीं सेटा 19 नहीं एटा बोले 15 ना कोन लागु
15/2/2008
हां
15/2/2008
सेटा कहला जी बेलर फाइल्स a petition that he wants to produce the accused today
on the strength of an advance petition. It is advocate
face to face the accused in judicial ताले 15/2/2008 रे निया गला पुनी 15/2/2008 ଠୁ ତାପରେ ଆଉ ଟ୍ରାଏଲ ପର୍ଯ୍ୟନ୍ତ ଆଉ କଣ ବେଲରେ ଯାଇଛି ସରିବା ପର୍ଯ୍ୟନ୍ତ produced sorry no. So then judgment ହେଲା 23/4/2008 ରେ judgment taken to custody. Okay, now High Court रे केतेବେଳେ केबे 7/3/2012
Yes.
released.
3 ବର୍ଷ 7 ମାସ
ତାମାନେ 15/2/2008 ଠୁ ଇଏ ହେଲା 12 ହେଲେ ଇଏ ହେଲା 4 ବର୍ଷ ମାସେ ହଉଛି ନା 4 ବର୍ଷ ତ 4 years 7 months. So, Mr.
Yes,
Tripathi, what do you want to say?
That
The
so
background in which this occurrence has taken place. Just think of a person who was of that
Yes.
tribal community. When he sees his wife in the bedroom of a person and in such a position. So obviously, what he has
Sudden
submitted is a
provocation,
proven, and that's why suppose he assaulted his wife and one blow on the head that proved to be fatal because the other parts are on the non-vital part of the body. A circumstance, is it not that exception 4 would be attracted 304? So it would be 304
Four.
part 2.
Two.
Okay. Correct. The appellant Levin Kerketa faced trial in the court of Additional Session Judge Raurkala in Sessions Trial number 115/42 of 2001 for offense punishable under Section 302 of the Indian Penal Code. The accusation that on 2/1/2001 in the house of the deceased, Lodha Khadia, he committed the murder of the deceased intentionally by a lathi, causing his death. The London Trial Court, by judgment and order dated 23/4/2008, found the appellant guilty under Section 302 of the Indian Penal Code and sentenced him to undergo life imprisonment and to pay a fine of ₹2,000. In default to undergo rigorous imprisonment for 1 month more. As per the first information lodged by Anup Kumar Singh PW3 before
Yes.
Huh?
PW3.
before Inspector in charge of Plant Site Police Station on 3/1/2001 is that ten years prior to the occurrence, he was staying with his family in village Sitalpada,
Close to the house of the deceased.
which is close to the house of the deceased. On 2/1/2001 at about 7 p.m., while the informant was present in the house, while PW3 was present in the house, he heard assault sound from the house of the deceased, and and the deceased shouting Marigali, Mago Marigali, inverted comma ভিতরে. Hearing such shout of the deceased, the PW3 came to the house of the deceased and found that the appellant was assaulting the deceased with a lathi. At that time, the wife of the appellant, namely Tarsila Kerketa, bracket PW2 na?
1.
PW,
Tarsila.
Tarsila acha PW1. PW1 was present in the house of the deceased and the appellant suspecting that the deceased had illicit relationship with PW1, assaulted the deceased as well as PW1. On account of such assault, the deceased sustained injuries on his head, leg, serious injuries, and PW1 also sustained injury on her hand. PW3 requested the appellant not to assault the deceased father. On the report submitted, on the basis of the oral report submitted by PW3, it was reduced to writing by the SI of Police, Udit Nagar Outpost, and the report was sent to Plant Site Police Station for its registration, and accordingly, the inspector in charge of Plant Site Police Station registered Plant Site PS case number 4 dated 3/1/2001 under section 307 of the Indian Penal Code. Stop. The IO is PW 15. Achha. PW 15 से जो SI of police टा उसी से जो PW 15 से ही bracket कर दो, हाँ. PW 15 took up investigation of the case, examined the witnesses, sent the deceased who was in an injured condition to Raurkela Government Hospital for his treatment. On his requisition, the scientific officer visited the spot for collection of physical clues. The IO visited the spot also on 4/1/2001, and though the case was initially registered under section 307 of the Indian Penal Code, but after the deceased succumbed to the injuries on on 3/1/2001, the case turned to one under section 302 of the Indian Penal Code. The scientific officer collected materials from the spot, materials like bloodstain Kantha, bloodstain R sample, earth, broken glass bangles, and other incriminating materials as per seizure list exhibit 1.
PW9 scientific officer.
Scientific officer bracketed PW9 like that. And came to RGH hospital, where he conducted inquest over the dead body in presence of the witnesses and prepared the inquest report exhibit 9, and then sent the dead body for post-mortem examination. The appellant was taken into custody, and while in police custody, he laid on the basis of his statement, the weapon of offense, that is lathi, was seized from inside a bush near Shitalpada Nali, and as per seizure list exhibit 12.
Lathi MO1.
Lathi the M1. After the postmortem examination, the wearing apparels and other belongings of the deceased were produced by the constable who had escorted the by the constable who had escorted the dead body, and those were also seized uh, along with the nail clippings, blood samples by the IO. The weapon of offense was sent to the medical officer who conducted the autopsy for seeking his opinion regarding possibility of the injury by such weapon and the cause of death. And the query report was received from the medical officer, and the IO also seized the bedded ticket from the hospital station diary of Udit Nagar outpost as per seizure list exhibit 8 and 6 respectively.
Query report 13. Exhibit.
Query
report exhibit
13 हाँ exhibit 13 करते and the material objects were sent for chemical analysis through the SDGM PANPOS, and chemical examination report bracketary exhibit 14 was obtained. On completion of investigation, charge sheet was submitted against the appellant under section 302 of the Indian Penal Code. In order to prove its case, the prosecution examined 15 witnesses. And these are the exhibits proved. Material objects, the came to hold that the death of the deceased was homicidal in nature. The Lennon trial court, relying on the evidence of the eyewitness bracket PW8, who is none else than the mother of the deceased, coupled with the recovery of the weapon of offense MO1 at the instance of the appellant, held that the prosecution has successfully established that the appellant committed the murder of the deceased, and accordingly found him guilty under section 302 of the Indian Penal Code. Mr. Ellen Patel, Land Counsel for the appellant, contended that the evidence of the eyewitness, who is none else than the mother of the deceased, is not clinching, and that should not have been taken into account for convicting the accused, the appellant. And since the prosecution case is that the wife of the appellant was found in the bedroom of the deceased, which was seen by the appellant, in all probability, there was grave and sudden provocation to the appellant, and the spur of moment he assaulted not only his wife, bracket PW1, but also the deceased. And the postmortem report indicates that one injury on the head proved to be fatal, and in view of the surrounding circumstances under which the crime has been committed, even if the evidence of PW8 is accepted, then it would not be a case which would attract the ingredients of the offense under section 302 of the Indian Penal Code, but it would squarely fall within exception 4 of section 300 of the Indian Penal Code. And the liability would be one under section 304 part 2 of the Indian Penal Code. The Learned Counsel further submitted that the appellant was taken into custody on 5/1/2001, and thereafter he was released on bail about 7 months, after 7 months, and then he was again taken into judicial custody during trial on 15/2008, and after the pronouncement of the judgment in this honorable court has granted him bail on 7/3/2012. And as such, the appellant has remained in custody for about 4 years and 7 months. And since the occurrence has taken place in the year 2001, and in the meantime, more than 22 years have already passed, taking into account the background of the case and the status of the appellant, and the surrounding circumstances under which the occurrence has taken place, the sentence be reduced to period already undergone. Mr. Tripathi, Learned Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that the postmortem report has been marked on admission as Exhibit 15, and as per the opinion of the doctor, the cause of death was due to injury to the vital vital structure, that is brain, and the doctor has also noticed injuries on other parts of the body apart from the head, and PW5 was only present when the occurrence took place, and she, being the mother of the deceased, is not expected to leave the real culprit and entangle the appellant falsely, and she stated about the occurrence in detail, and in the cross-examination, nothing has been brought out to disbelieve her evidence. And at the instance of the appellant, the weapon of offense has also been seized by the investigating officer, and therefore the Lennon trial court has rightly convicted the appellant under section 302 of the Indian Penal Code. Adverting to the contention raised by the Lennon counsel for the respective parties, let us first see how far the the prosecution has proved that the deceased died a homicidal death. There is no dispute that the doctor who conducted post-mortem examination has not been examined during trial, but on verification of the order sheet of the Lennon trial court, it appears that on 18/4/2008, the Lennon State Defense Counsel was appearing for the appellant, filed a memo admitting the PM report, and in view of the memo filed by the Lennon State Defense Counsel, the Lennon trial court marked the PM report as Exhibit 15 and dispensed with the attendance of the doctor. The postmortem report indicates that the deceased had sustained one abrasion on the lateral angle of the right eye, one lacerated wound on the right shoulder, 1 cm into half cm over the right. Another lacerated wound on the below the left knee, one abrasion on the left elbow, and lacerated wound on the right side forehead, 3 cm, 2 cm, and in the portion of the body scalp cleaner. So you are looking 1 cm, half cm, and half cm on the scalp. Then a lacerated wound on the right side of the forehead, 3 cm, 2 cm, and bone deep, and a linear fracture 4-inch in length on the frontal bone below the injury, below the above injury. And all these injuries were opined to be ante-mortem in nature, and age of the injuries were about 12 to 24 hours. And the death was opined to be due to injury to the vital structure, the brain. In view of the post-mortem report finding and the post-mortem report, in view of the post-mortem report finding, we are of the humble view that the Lennon trial court has rightly came to the conclusion that the prosecution has successfully established that the deceased met with a homicidal death. Stop. The though PW3, the informant, lost the first information wherein he posed himself as an eyewitness to the occurrence, but during trial, he has not supported the prosecution case for which he was declared hostile by the prosecution. PW1, the wife of the appellant has also been declared hostile. The star witness on behalf of examined from the side of the prosecution is none else than the mother of the deceased, who has been examined as PW8. She stated that the wife of the appellant was sitting near the deceased in her house, and at that time the appellant came there and gave lathi blows to PW1, and she left the place, and then he assaulted the deceased on his head by means of lathi, and for which the deceased sustained severe bleeding injury, and subsequently he died in the hospital. PW8 specifically stated that she was alone present at that time in her house and seen the occurrence. She further stated that even though her son shouted and she also raised halla, but nobody turned up and the appellant escaped. In the cross-examination, she has stated that the house of the appellant is situated at a distance of 20 to 25 cubits from the house of her deceased son. She further stated that they enjoyed drinks and food throughout the day in the evening hours. And the appellant had come to their house to Handia, and in her house at the time of occurrence, a debris lamp was burning and the surrounding was dark. And they were taking food either on the veranda or in the house. And after fooding, after taking food, the appellant left from the house of the deceased, and in Tuesday morning, that on the next day, that is on Tuesday morning, they came to Shitalpada, and in the evening hours, the incident took place at Shitalpada. In the further cross-examination, she has stated that she had seen the assault on the deceased, and except she herself and the deceased son, none else were present in the house. Nothing further has been brought out in the cross-examination to disbelieve the evidence of PW8. After going through the evidence of the star witness, we find that our evidence inspires confidence, and she is a reliable witness, and being the mother of the deceased, she is not likely to spare the uh, real culprit and accuse somebody falsely. The appellant was arrested, and it appears from the evidence of the investigating officer PW 15 that at the instance of the appellant, basing on his recorded statement, the weapon of offense, that is the body lathi MO1, was recovered from inside a bush near Sital Pada Nali, and the same was seized as per seizure list exhibit 12. The weapon of offense after its seizure was sent to the medical officer who conducted the post-mortem examination to ascertain the possibility of the injury noticed on the person of the deceased by such weapon, and the query report has been marked as exhibit 13, and it indicates that the injuries on the body of the deceased could have been caused by MO1, and the injuries on the right side of the forehead, and the underlying fracture of the frontal bone and the injury to the underlying brain substance were sufficient to cause death to the deceased. Stop. Therefore, in view of the available evidence on record, we are of the view that on account of the assault made by the appellant with the lathi bracketry MO1, the deceased sustained injury which ultimately resulted in his death. Now the question crops up for consideration whether the act of the accused would come within the purview of Section 302 of the Indian Penal Code as held by the London Trial Court, or any of the exceptions under Section 300 would be attracted. Taking into account the evidence on record as adduced by PW8, it indicates that during the evening hour on the date of occurrence, inside the bedroom of the deceased, the wife of the appellant was found present, and at that time a lamp was burning, and the appellant saw his wife in such a position, and in all probability the it appears to have created grave and sudden provocation to the appellant, finding his wife in the company of the deceased. The appellant assaulted the deceased, and also the appellant assaulted the PW1 and also the deceased on the spur of the moment. And though number of injuries have been noticed on the person of the deceased, but it appears that only one injury was caused to the vital part of the body, that is the head, which resulted in fracture of the frontal bone and also caused injury to the brain, which ultimately resulted in the death of the deceased. In the surrounding circumstances, we are of the view that the occurrence having been taken place in the grave and on account of the grave and sudden provocation of the appellant in the spur of the moment, uh, in a fit of anger, seeing his wife with the appellant in the bedroom of the appellant in during that period, that time of the evening hours, um, the uh, exception 4 would be squarely applicable in this case. Exception 4 to section 300 of the Indian Penal Code would be squarely applicable to this case. And accordingly, we're of the view that the case would fall within section 304 part 2 of the Indian Penal Code. Accordingly, the conviction of the appellant under section 302 of the Indian Penal Code is hereby set aside, and the conviction is altered to one under section 304 part 2 of the Indian Penal Code. And since, as submitted by the learned counsel for the appellant, and on verification of the order sheet, we find that the appellant has remained in judicial custody at different point of time in connection with this case for 4 years and 7 months, and in the meantime more than 22 years have already been passed, and the appellant is now on bail. We we sentence the appellant to period already undergone. Accordingly, the jail criminal appeal is allowed in part. The That's all. The-
Okay.
Hit number beta फिलहाल
28.
28. Yes, what is Mrs. Tripathi? Adjournment. कौन ପାଇଁ?
ଆମେ ତ କାଲି ପଚାରିଲୁ ତାଙ୍କୁ।
କାଲି ପଚାରିଲୁ, ସେ କହିଲେ
To me also, she had stated that she will be here and do it first.
oh, she should have sent somebody, not that message कौन है क्या Her sister is also
Yes, yes.
coming to
She also.
court, and when a part had matter, how can ବହୁତ କେସ୍ ତାଙ୍କୁ ଦିଆ ହଉଛି ଜେଲ କ୍ରିମିନାଲ ଅପିଲ।
ଅଧା ଆସୁନାହାନ୍ତି ନେଇକି ପଢୁଛନ୍ତି।
ଏଇଟା ସବୁ
ତାକୁ ପଠେଇଥିଲେ କେବେ କାଲିକୁ ରଖିଲେ ନା କଣ କିଛି କହିଲେ?
36 तो आपनकर पावर भी अछि हाँ
He is interested to contest. Yes.
no premature सुनो जोड़ा करे
Oh.
premature release होउची ता देरे premature release रे 433 रे देखिबे तार गोटे कंडीशन स्टिपुलेटेड हेइता जे जदि से माने भायोलेट कले केते बेले जे गोटे गोटे लेखा हेइता इफ द रिजल्ट ऑफ द अपील शुड डिजायर तेणु सेठी पावर अछि जे ये कर देबे आपण जस्ट देखि
430, yes.
433 रो सीआरपीसी तेणु आपण सेई जो आनिले सेटा जणा पड़ी जीवो जे ता देरे प्राय आउ से that is to be passed only on the basis of the opinion given by the report of the trial court or wherever the case is pending. I think let us see that again 433 432 अच्छा हाँ 432 also 432 is power to suspend or remit sentence when any person has been sentenced to a punishment for an offense, the appropriate government may at any time, without condition or upon any condition, with the person's sentence, accept, suspend the execution of his sentence, and remit the whole or any part of the punishment to which he has been sentenced. Number two, whenever an application is made to the appropriate government for suspension or remission of the sentence, the appropriate government may require the presiding judge of the court before or by which the conviction was heard or confirmed to state his opinion as to whether the application should be granted or refused. This is mandatory. It has been held by the Honorable Supreme Court. Together with the reasons for such opinion, and also to forward with the statement of such opinion a certified copy of the record of the trial of such record thereof as exists. If any condition in which the sentence has been suspended or remitted, in the opinion of the appropriate government, not fulfilled, the appropriate government may cancel the suspension or remission, and thereafter the person in whose favor the sentence has been suspended or remitted may, if at large, be arrested by any police officer without warrant and remanded to undergo the see you कंडीशन गुड़ाकरे अधिकांश समय करिथांदी जे हमर एई टाइप रो बिहेवियर करिवो इंक्लूडिंग गोटे कंडीशन समटाइम्स थाए जे सिंस जो गुड़ाकरे अपील पेंडिंग अछि एठी तांकु दिया आइछि तेणु सेगुड़ा से एथिरे डिटेल लेखा आइथिबो माने एठारे आपण से लेखा होछि जो कुआडा गला केते नंबर आइटम सेटा आपनकर
36
36 प्रीमैच्योर रिलीज रिपोर्ट एट फ्लैग एटा टी देखियो कोन लेखा है ନାଇଁ ଆଦିରେ କିଛି ଲେଖା ହେଇନି ଖାଲି ଗୋଟେ ଦେଇଦେଲେ କୋଉ କୋଉ ଜିଲ୍ଲାରୁ କିଏ ଗଲେ ସେମିତି କଣ ଏଇଥିରେ ଆଣିଲେ ଦେଖିବେ so Mr. Patel, you see the law is very clear that merely because you are released prematurely that doesn't mean that your conviction goes. Conviction still remains. And the court has the appellate court has the power to adjudicate the now we are asking in the another case also that what will happen if suppose during the pendency of the appeal he has been prematurely released but the court takes off the matter subsequently and the conviction is confirmed. Let us see what will happen. There is a 5 judgment decision you will find on this particular aspect that they have no doubt the power, the appropriate government has power and the procedure has been laid down and it is to be done in that manner. That means the opinion, etc., etc. And if condition, but it is all these things are subject to the result of the appeal. Appellate court taku found karibo once it is found to be guilty that he has to be taken into custody then you can exercise also your power. बुझी पारले ना आपण सेही स्टेज रे पेंडेंसी ऑफ द अपील ले करथले तापरे आमे that doesn't mean that se acquittal heigala, conviction rahila. Conviction ଯେତେବେଳେ appeal ରେ decide ହବ ଏବଂ ଆମେ ତାକୁ confirm କରିବୁ, then he has to be again taken into judicial custody, and then again you have got that power. ଆପଣ remit କରିଦେଇ commute କରିଦେଇ ପାରିବେ. So that is you can examine there are decisions to that effect. ନହେଲେ ତ ମାନେ absolutely ଯୋଉଥିରେ ଆପଣ ଛାଡିଦେବେ ପ୍ରିମ୍ୟାଚୁଅରଲି ସେଠି ତା appeal ଟା ଯାଉନା, ସିଏ ଯଦି କହିବ ନା ମୋର ଆଉ ପ୍ରିମ୍ୟାଚୁଅରଲି ଗଲାଣି ମୁଁ ଆକୁ ପ୍ରେସ୍ କରିବିନି, ଧର ଏମିତି କହେ, ବଟ୍ ପ୍ରେସ୍ କରିବନି ମାନେ ନୁହେଁ ଯେ ତାର କନଭିକ୍ସନ ଟା କଟିଗଲା, କନଭିକ୍ସନ ରିମେନ୍ସ ଦେୟାର। ସେଇଥିପାଇଁ ଆପଣ ମୁଁ ସେଇ ୟୁ ଆର୍ ଟେଲିଂ ଦ୍ୟାଟ୍ ଏଇ ଯୋଉ ୟା ଦେହରେ ଡିଟେଲ କିଛି ଲେଖା ହେଇନି, ଖାଲି ଯୋଉଟା ଫ୍ଲାଗ ଏ ରେ ଅଛି ନା ତା ଦେହରେ କେତେ ଗୁଡାକ କନଭିକ୍ଟ କୁ ଲାଇଫ କନଭିକ୍ଟ କୁ ଛଡା ହେଇଛି, ଖାଲି ସେଇ ବିଷୟରେ ଇଣ୍ଡିକେଟ ହେଇଛି। ବଟ୍ ହ୍ୱାଟ ୱାଜ ଦି କଣ୍ଡିସନ, ହ୍ୱାଟ ୱାଜ ଦି ରିଜନ, ସେଇଟା ଗୋଟେ ଡିଟେଲ ତାର ଗୋଟେ ସେପାରେଟ ଫାଇଲ ଥାଏ ପ୍ରତ୍ୟେକ ଇଏର। ତେଣୁ ତାର ପ୍ରୋସିଡ୍ୟୁର ଅଛି, ଜଣେ ଏଠି ଯୋଉ ଅଛି ଆପ୍ଲିକେସନ ଦବ, ସେ ଆପ୍ଲିକେସନ ପାଇଲା ପରେ ଆପ୍ରୋପ୍ରିଏଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କଣ କରିବ ନା ଓପିନିଅନ ମାଗିବ, ଏସବୁ ଜିନିଷ ଯୋଉ ଲେଟ୍ ଡାଉନ ହେଇଛି। ହଁ see, if that procedure is not for you, your premature release would be illegal. You cannot just see application dela, suppose you are a political person, see ଦେଇଦେଲା ଆପଣଙ୍କର party is in power, ତାକୁ ଆପଣ ଛାଡିଦେଲେ ସେମିତି accept କରି, that would not be proper, that would be illegal, because the law prescribes that if you want to remit the sentence, what procedure has to be followed. ତେଣୁ ଏଠି ଯୋଉ କେସରେ ତେଣୁ if you can produce that the original the reasoning, and particularly ସେଥିରେ ନିଶ୍ଚୟ ଥାଏ ତା ଦେହରେ, କାରଣ in some cases we have verified that that was the condition that he should maintain this ଏଇ type ର କୌଣସି କେସ୍ ରେ ସେ ଇନଭଲ୍ଭ ହବନି, ତା ଦେହରେ କଣ୍ଡିସନ ଥାଏ, ଗୋଟେ ଜେନେରାଲ ଇଏ କିନ୍ ଥାଏ, and including that last condition ବୋଧେ ଥାଏ, ସେ ଯୋଉ appeal ଯେହେତୁ pending ଅଛି ତାର ଇଏଟା ଥାଏ, that you can get in detail. No, ଆପଣଙ୍କର ଏଇଟା appropriate government decision ନେଇଛି, decision ନେଇକି exhibit ଏଟା,
this is only an information to the
ହଁ ଯେ ଆମେ appropriate government ର decision ଟା communicate ହେଲା ମାନେ prison authority କୁ, ତେଣୁ
Mr. Tripathi was saying that jail must be having the copy of this original order. Yes.
original ଏଟା maybe original ଥାଇପାରେ, ନଚେତ ଏମିତିଆ ଯଦି ଗୋଟେ ପହଞ୍ଚିଥିବ ଯେମିତି ଆମ ପାଖରେ ପହଞ୍ଚିଛି ଆସିକିନି ଫ୍ଲାଗ ଏରେ, ଯେ ସେମାନଙ୍କୁ ତେଣୁ କଣ ପହଞ୍ଚିଛି ଦେଖି ଦିଅନ୍ତୁ either if it is available with the jail authorities, IG prisons ପାଖରେ ଥିବ, IG prisons ପାଖରେ ସବୁତକ ପହଞ୍ଚି ଗଲା ପରେ ସିଏ ଗୋଟେ ତାକୁ ସମରାଇଜ କରିଦେଇଛନ୍ତି ଯେ ଏଇ ଯୋଉ ଆମ ପାଖକୁ ଯାହା ଆସିଛି ଯେ ଏଇ ଲୋକ ଗୁଡାକ ତାଙ୍କର କନଭିକ୍ଟ ନମ୍ବର ହେଇଗଲା ଏଇଆ, ଆଉ ସେମାନଙ୍କୁ ପ୍ରିମ୍ୟାଚୁଅର ରିଲିଜ କରିଦିଆଗଲା, ତା ନାଁ ସବୁ ଦିଆ ହେଇଗଲା, ତାଙ୍କୁ ଛାଡି ଦିଆଗଲା। So
out of that also some cases have been disposed of. Item number 12, the serial number 12, 21, these matters have already been disposed of. এটা দেখতে পারলে পড়িব Mysore দ্বারা 4783 JCRL 42 of 2016 probably.
ନାଇଁ ଏଇଟା ସେ ଯୋଉ ଲେଖିଛନ୍ତି ଏଇଟା ମାନେ ସେ ତାମାନେ କ୍ରିମିନାଲ ଅପିଲ ଡିସ୍ପୋଜ ଅଫ ହେଇଯାଇଥିଲା, ତାପରେ ତାଙ୍କୁ ରେମିସନ ଦିଆହେଇକି ଛଡା ହେଇଛି, ରାଇଟ୍? ହଁ, ତ ଏଇଟା ଏଗୁଡାକ ସବୁ ମେରିଟ ରେ ଡିସାଇଡ ହେଇଯାଇଛି ଯୋଉଗୁଡାକ ଲେଖା ହେଇଛି, ବଟ୍ ଏଇ ଯୋଉଗୁଡାକ ଛକି ମରା ହେଇଛି ଏଗୁଡାକ ପେଣ୍ଡିଂ ଥିଲା, ପେଣ୍ଡିଂ ରେ ଏମାନଙ୍କୁ ପ୍ରିମ୍ୟାଚୁଅର ରିଲିଜ କରାହବ।
Who is your এটা କିଏ ଆମ petitioner, এটা appellant କିଏ? Name of the appellant is judgment is not visible.
এটা କେତେ ନମ୍ବର ଆଇଟମ କେତେଟା କହିଲେ ମିଷ୍ଟର ପଟେଲ?
ତାର ନାଁଟା ଦେଖିଲେ 36
ମିଟୁ ଆଲିଆସ ଅଶୋକ ସ୍ୱାଇଁ,
ମିଟୁ alias
ତା ନାଁ ଥିବ ବୋଧେ ମିଟୁ ଆଲିଆସ ଅଶୋକ ସ୍ୱାଇଁ। that is 27, 27 number. We are handing over a copy of this exhibit flag area जो document आची आमे आपन को hand over कर दोछु आपण instruction नहीं जानतु right सेटा produce कर दियंतु माने you will find that तांकर सेई type रो जो we have seen reject हेले भी कोन से माने दियंती reasoning जोटा की challenge हुए most of the time WPCRL हेगिन challenge so but you prepare yourself.
Yes.
Because the reason is that suppose in case on we dismiss the appeal hala तो confirm ही गला confirmation टा communicate immediately ही जो trial court hala जल्दी से condition थिबो ये रे ताले immediately will be taken into custody तेणु and law is very clear that appellate decision ultimately जो pending थिबो यदि appellate court गुटे decision नबो तापरे again that is to be that to supersede तापरे appropriate government ro power अछि again they can remit that. That's very clear sir. शुणु आपण ए जो काउंसिल मान को एटलिस्ट जानी चनी ताऊ कहंतु तो काली भीतर जदि समाने न रहिबे हम पाखरे पैनल लिस्ट अछि तो पैनल लिस्ट अनुसार जो एडवोकेट्स माने थिबे प्रेजेंट थिबे and से पैनल लिस्ट प्रिपेयर हिची on the basis of the experience 10 years experience दरकार ना तो पैनल लिस्ट अछि हमें एंगेज कर दबु एंगेज करी पेपर बुक देई कि नै जो सो गोटे 2008 रो एगुडा सबु तक 2008 रो अपील and all these persons are regular practitioners and they will not even come to the court to say something that whether they have received the paper book or not. इतने lightly केमती जने नव life imprisonment case उड़ा. Why the legal services authority has reposed confidence on you to argue a 302 case? मैडम को कही देवे है ना I will simply write that henceforth no case will be entrusted to her. This is not the way. Almost the argument was over. Today the date was fixed to file the citations only, and Mr. Mishra had come prepared, and she would not dare even to send somebody. She will send a message to you.
For your lordship since last 8 weeks before vacation, and because of shortage of time, it didn't reach. Criminal appeal.
My lord.
I pray for it because my interim order is going to expire on 10th.
Bail matter.
It's not bail, it's a peculiar case, my lord.
अरे कौन टा
Appeal. Regular appeal.
appeal माने hearing पे कोई
नहीं, press admission.
दियन तो ना
My lord, my lord,
Come
it is a interim bail petition, my lord. That previously 4 months ela sida reach kolani to my lord. Tomorrow, your lordship may allow.
June,
Yes, my lord, tomorrow.
Petitioner health is not good in custody. Therefore, petitioner admitted versus medical खुला पाए health show
June.
interim bail मांगे. For interim bail.
June.
Expiring on
June.
bail matter under TPC.
For
the extension of interim bail.
June. June.
Directed to list on fact.
List করে দাও দেখি তো। Yes.
My lord, I may be permitted to make. My lord, item 23, your lordship's list today.
26.
23. That is
Hearing list.
CRLA 259 by 2010. That your lordship has specifically directed to file the written note of argument we have already filed. That is, my lord has fixed it to 6/4/2023 in the supplemental list for disposal. But before vacation, bail matters were taken up. Written note from our side already filed. Your lordship, any date my lord may fix.
ସେ ରୁହନ୍ତୁ ଆମେ ସିରିୟଲି କରି ଯିବି ଯିଏ ରହିବ ତାକୁ ଟେକ୍ ଅପ୍ କରିବେ ଆପଣ
23
ପଡିଯିବ
ଆଜ୍ଞା 23 ଟା ଟିକେ ରିଚ୍ ନ କରିପାରେ ମୁଁ କହୁଛି ଟିକେ ସପ୍ଲିମେଣ୍ଟାରୀ ଗୋଟେ ଦିନ ଆସୁ
ନାଇଁ ସପ୍ଲିମେଣ୍ଟାରୀ ତ ଆସୁଛି ୱିକଲି ଲିଷ୍ଟରେ ଆଜି ଫାର୍ଷ୍ଟ ଆୱାରରେ ଉଠିକି ସେଇଥିପାଇଁ ଶୀଘ୍ର ଗଲୁ କେହି ନଥିଲେ ହିୟରିଂ ମ୍ୟାଟର
My lord directed to be listed on in bail matter. But before vacation.
Hmm.
But again, it has listed in the hearing because out of 10 years, he is already 8 years in custody.
ନା ଆପଣ ସେ ବେଲ୍ ଖାଲି 3 ମାସିଆ ନେଇ ପଳେଇ ଯାଉଛନ୍ତି ନା ଆଉ ଆସୁନାହାନ୍ତି ହିୟରିଂ ବେଳାଉ
This time he has surrendered.
Rainer, you get ready I will take up this matter. Yes.
Item 50 my lord. Item 50 of the list. My lord, this is CHITTARANJAN master. I this Opalakuma on behalf of the appellant. That has not been rejected in the
କୋଉଟା
item number 50.
ସେଇଟା କଣ ଆଣିକି ଓକାଲତନାମା ସାମିଲ କରିଦିଅନ୍ତୁ ତାଙ୍କୁ ହେଲା it will come and
Sir, I beg pardon, my item 44, man. I filed a bail petition. My lord, his mother is ill. And for that reason, my lord, let it taken up for bail. 8 years, 9 months are already gone out of 10 years.
44 ର କଣ instruction ନେଇ ଯାଆନ୍ତୁ ଦେଖିବ Mr. Tripathi.
Yes.
Yes.
21. Here a mention had been made when your lordship was sitting for the whole day. And your lordship had fixed the date. Unfortunately, thereafter,
21.
Yes.
It
will be taken up someday at the top of the list so that I can.
ଟିକେ ରହନ୍ତୁ ଆଜି ଯଦି କିଛି ନଥିବ ଆଜି ନେଇଯିବା କିଛି ଅସୁବିଧା ନାହିଁ.
An item 41. It's a vigilance matter. The fact is that it's a trap case. The complainant he was found that he had committed some fraud and he has taken out some money. The BDO had directed the JEA and cashier to recover the amount. ଯେତେବେଳେ ସେ ପଇସା ଫେରେଇବାକୁ ଯାଇଛି ସେତେବେଳେ ତାକୁ ଭିଜିଲାନ୍ସ ଧରିଛନ୍ତି. This is the fact of the case. So I had informed the vigilance council that maybe I'll be mentioning it will be taken up any day lordship.
ସେ ନାହାନ୍ତି ତାଙ୍କର ତ
ମୁଁ କହିଥିଲି ମେସେଜ ବି କରିଥିଲି but any day lordship ସେ ଆସିଯିବ
ତାଙ୍କୁ
ତା
ଡାକି
ସର୍ଭିସ ଟା ସରି ଯିବ.
ଯିଏ ପ୍ରେଜେଣ୍ଟ ରହିବ ମୁଁ ତା କେସ୍ ନେବି ଯେ ତାଙ୍କୁ ଡାକି ଦିଅନ୍ତୁ.
ଆଜ୍ଞା I'll call for that.
Yes, call the matter. पूरा 1 नु डाकी दी चल जाऊं.
Weekly list item number 1.
May I please, your lordship?
Yes.
On behalf of the Siddharth, may I be allowed to submit, my lord? In this case, the appellant was initially charged under section 498A, 304B, 302, and 34 IPC. Subsequently, while convicting the appellant, there were 3 accused, but 2 of the accused were acquitted, and the present appellant was convicted under section 302.
This man is the
husband.
And the Bashyanti Naik who was facing trial is the
sister of the appellant.
Sister of the appellant. And Kailash Chandra Naik?
The husband of the Bashyanti Naik.
Okay. So the charge was 498A by 34, then 304B by 34, then 302 by 34, right? And trial court judgment indicates that 498A, 304B, 302. That was all these charges they were acquitted. Those two, sister and sister's husband, right?
My lord.
And this appellant was found. Okay, he was acquitted of the charge under 302, but he was found guilty under 498A, 304B, right?
My lord.
So the sentence is RI for 7 years, 304B, RI for 1 year, 498A, and concurrently. So it's 7 years, right? All right. Place the FIR.
My lord. My lord, information is the father of the deceased. ମୋର ନାମ ଶ୍ରୀ ରାମଚନ୍ଦ୍ର ମହାନ୍ତି, ବୟସ 60।
Ramchandra Mahanti, PW.
6 my lord।
नाली पेन पेंसिल। हाँ, कितने नंबर सखी?
6।
पढ़ंदु।
ମୋର ନାମ ରାମଚନ୍ଦ୍ର ମହାନ୍ତି, ପିତା ସୁବାଂଶୁ ମହିମା। ଆଜି ତାରିଖ ଏତିକି ଦିନ।
पे माइक टाକୁ ସାମ୍ନାରେ କୁହନ୍ତୁ।
ଆଜି ତାରିଖ 3ଟା ସମୟରେ କପ୍ତିପଦା ଥାନାରେ ହାଜର ହୋଇ ଆପଣଙ୍କ ନିକଟରେ ଏହି ମୌଖିକ ବୟାନ ରିପୋର୍ଟ ଦେଉଅଛି ଯେ ମୋର ସାନ ମଝିଆ ଝିଅ ମିନତି ବୟସ 21 ବର୍ଷଙ୍କୁ ଗତ 1996 ମସିହା ଆଷାଢ ମାସ ଅର୍ଥାତ୍ ଆଜକୁ ପ୍ରାୟ 1 ବର୍ଷ 4 ମାସ ତଳେ ରଥିପୁର ମୌଜାର ଭାନୁଚରଣ ପ୍ରଧାନ ପିତା ସୁବାଂଶୁ ବୈଦିକ
ଭାନୁ ପ୍ରଧାନ means appellant. Yes.
ବୈଦିକ ରୀତିରେ ବିବାହ ଦେଇଥିଲୁ। ଘରୋଇ ଗଣ୍ଡଗୋଳକୁ ନେଇ ମୋର ଜ୍ୱାଇଁ ତାର ବାପଠାରୁ ଅଲଗା ହୋଇ ମୋର ଝିଅକୁ ନେଇ ବରସିମୂଳିଆ ମୌଜାରେ ଆଜକୁ ପ୍ରାୟ 4 ମାସ ହେବ ଘର କରି ରହିଥିଲା। ଆଜି ଦିନ ପ୍ରାୟ 11ଟା ସମୟରେ ଆମ ଗାଁର ବିଜୟ ଦାସ ପିତା ସୁବାଂଶୁ ତିହିଡି ସ୍କୁଲରେ ଶିକ୍ଷକ
examine ହେଇଛନ୍ତି?
No my lord, he was not been examined.
Vijay Das not examined.
Not.
All right, next. ପଢନ୍ତୁ।
ଶିକ୍ଷକ କାମ କରନ୍ତି। ଆମ ଘରେ ଖବର ଦେଲେ ଯେ ତମ ଝିଅ ମିନତି ମରିଯାଇଅଛି। ଖବର ପାଇ ମୁଁ ମୋର ବଡ ଭାଇ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର, ସାନ ଭାଇ କୈଳାସ ଚନ୍ଦ୍ର ମହାନ୍ତି ମିଶି ବଡସିମୂଳିଆ ଗାଁକୁ ଗଲୁ ଏବଂ ସେଠାରେ ଯାଇ ଦେଖିଲୁ ମୋର ଝିଅ ଗୋଟିଏ ସପର ଉପରେ ତାର ରହୁଥିବା ଘରେ ମରି ପଡିଅଛି। ତା ପାଖରେ ତାର ବର ବସିଅଛି।
ବର means the present appellant.
ମୁଁ ତାକୁ କଣ ଖବର ପଚାରିବାରେ ସେ କହିଲା ଆଜି 10ଟାରେ ବିଷ ଖାଇ ମରି ଯାଇଅଛି। ମୁଁ ତାକୁ କହିଥିଲି ତୁ ଶେଷକୁ ଏଇଆ କଲୁ ନା ପିଟାପଟି କରି ମଣିଷଟାକୁ ମାରିଦେଲୁ। ଏହା କହି ମୋ ଝିଅର ମୃତ୍ୟୁରେ ମୋର ସନ୍ଦେହ ହେଉଥିବାରୁ ମୁଁ ମୋର ଭାଇମାନଙ୍କୁ ଲାଶଟିକୁ ଜଗାଇ ରଖାଇ ଖବର ଦେବା ପାଇଁ ଆସିଲି। ଆସୁଥିବା ବାଟରେ ମୋର ସେହି ଗ୍ରାମର ମୁଖିଆ ବଂଶୀଧର ପାତ୍ର ସହ
examine ହେଇଛି?
PW ବଂଶୀଧର ପାତ୍ର ସହ ଭେଟ ହେବାରୁ ସେ କହିଲେ ଯେ ସକାଳୁ ଆମେ ଏତେ ଶଳାକୁ ଆମେ ଏତେ ଜବତ କରିବା ପରେ ବି ଝିଅକୁ ପାଟିତୁଣ୍ଡ ପିଟାମରା କରିବାରୁ ବିଚରା ଝିଅଟା ମରିଗଲା। ପ୍ରକାଶ ଥାଉ କି ଏହି ବାହାଘରରେ ଆମ ଗାଁର କୃପା ସିନ୍ଧୁ ସାହୁ ମଧ୍ୟସ୍ଥତା
examine ହେଇଛି? କୃପା ସିନ୍ଧୁ ସାହୁ?
No my lord.
Not. Okay.
ମଧ୍ୟସ୍ଥତା କରିଥିଲେ। ବିବାହ ସମୟରେ ସେ ଆମର କଥାବାର୍ତ୍ତା ଅନୁସାରେ ଆମେ ବରପକ୍ଷ ଲୋକଙ୍କୁ ସେମାନଙ୍କର ଦାବି ମୁତାବକ ସମସ୍ତ ଜିନିଷ ଦେଇଥିଲୁ, ମାତ୍ର ଗୋଟିଏ ସୁନା ଚେନ୍ ଦେଇପାରି ନଥିଲୁ। ବାହାଘର ପରେ ପଇସା ଯୋଗାଡ଼ କରିଦେବୁ ବୋଲି କହିଥିଲୁ। ଏହା ନ ଦେଇ ପାରିବାରୁ ତାର ଶାଶୁ ଶ୍ୱଶୁର ନଣଦ ସ୍ୱାମୀ ଓ ଯା ତାର ନଣଦେଇ ତାକୁ ପିଟାମରା କରିବାରୁ ମୋର ଝିଅର ମାମୁଁ ଘରକୁ ଯାଇ ଶାଶୁ ଘରକୁ ଯାଇ ଆମ ଘରେ ରହୁଥିଲା ଏବଂ କିଛି ଦିନ ପରେ
ପଞ୍ଚାୟତରେ କି ପଞ୍ଚାୟତ ଗୋଟେ ଲେଖା ହେଇଛି?
ଏକ କମିଟି ହୋଇ ମୋ ଝିଅକୁ ପିଟାମରା ନ କରି ଭଲରେ ରଖିବା ପାଇଁ
ସେମାନେ ଲେଖିଦେଇ ଝିଅକୁ ତାଙ୍କ ଘରକୁ ନେଇଥିଲେ। ଏହାପରେ ସେମାନଙ୍କ ଘର ଭିତରେ କଣ ହେଲା କେଜାଣି ମୋର ଜ୍ୱାଇଁ ଝିଅକୁ ନେଇ ବଡ଼ସିମୁଳିଆରେ ରହୁଥିଲେ। ସେଠାରେ ସେମାନେ 2 ଜଣ ରହିଲେ ମଧ୍ୟ ମୋର ଜ୍ୱାଇଁ ଭାନୁଚରଣ ପ୍ରଧାନ ସବୁ ସମୟରେ ମୋ ଝିଅକୁ ପିଟାମରା କରନ୍ତି। ମଝିରେ ମଝିରେ ତାଙ୍କ ଘର ଲୋକ ମଧ୍ୟ ସେଠାକୁ ଯା ଆସ କରନ୍ତି ଯାଆନ୍ତି। ଗତ 20/8/97 ତାରିଖ ଦିନ ଝିଅ ତା ସ୍ୱାମୀ ତାକୁ ପିଟାମରା କରି ଥିବା ବିଷୟରେ ମୋ ପାଖକୁ ଚିଠି ଲେଖି ଜଣାଇଥିଲା। ଏଣୁ ମୋର ଉଦ୍ବୋଧ ହେଉଛି ଯେ ମୁଁ ସେମାନଙ୍କୁ ଦାବି ଅନୁସାରେ ସୁନା ଚେନ୍ ଦେଇ ନ ପାଇଥିବାରୁ ମୋର ଜ୍ୱାଇଁ ଓ ତାଙ୍କ ଘରର ଲୋକମାନେ ତାଙ୍କୁ ନିର୍ଯାତନା କରୁଥିଲେ, ଯାହାଫଳରେ କି ସେ ନିର୍ଯାତନା ସହି ନ ପାରି ବିଷ ଖାଇ ମରିଅଛି। ଏଣୁ ଏହି ରିପୋର୍ଟ ଦେଲି, ତଦନ୍ତ ହଉ।
So marriage is Ashadha 1996. Death is on 28/97. Deceased hala Minoti.
Death 27 FIR
27. अच्छा डेथ अच्छा 20 तारीख रे ताकू अच्छा मारधर करथिले और डेथ इज 27 होला। Okay, you straight first come to the doctor who conducted postmortem exam.
My lord, PW 13. On 28/9/97, the next day, I was working as the assistant surgeon in Uddara Hospital. That day, around 3:30 p.m. on police requisition, I conducted autopsy over the dead body Minati Pradhan, wife of Bhanucharan Pradhan of Rathipur, PS Kaptipada, so and so, and found as follows. Rigor mortis was present in both lower limbs. Eyes were closed. The face was puffy. The cyanosis was marked in lips and eyes limbs. There was facial discharge, sealing and the anal margin and the perineum. Abrasion of 2 centimeter, around 2 centimeter into 1.5 centimeter around in ulna of, my lord, it was
nose ଆଉ ଲେଖା ହେଇଛି ନାଇଁ ତଳେ ଲେଖା ହେଇଛି ନୋଜ ଲେଖା ହେଇଛି ସେ ଯୋଉ ଲେଟର ତଳେ ନୋଜ ହଁ
multiple crescenting mark arranged near curve line were situated below the left angle of mandible. Multiple abrasion on the nape of the neck. One contusion of 7.5 centimeter, 3 centimeter was situated over thalix, extending the body side. There was fracture of the hyoid bone at its right corner, and also there was fracture of laryngeal centilis. There were multiple abrasion on the middle of the medial of the left thigh. All the internal organs like brain, lungs, heart, liver were injured and congested. The injury was antemortem in nature. Death was caused due to asphyxia as a result of compression of air passage in the throat. This is sufficient in ordinary course to cause death. Death had occurrence within 24 to 36 hours.
So it's not a case of suicidal hanging or something like that. It's a case throttling, right?
Yes.
And as it appears, there are number of injuries on different parts of the body.
Yes, ma'am.
And due to throttling, the hyoid bone has fractured.
The 5 and 6.
So Okay. So what is the finding of the learned trial court on this aspect about what he has held about the death of the deceased?
My lord, the learned trial court held that
Page number finding
my
about
lord,
what is the
17.
nature of death.
17, my lord. Sorry.
Art quiz.
17 para 8, my lord.
17.
Para 8, my lord.
Running page 17.
My lord, paper book, my lord.
Paper book page 17. Hold on.
As already stated, on 27/9/97, at about 10 a.m., Minati died in her house at Borsimulia. Medical evidence on record disclosed that she had sustained injuries and fractures on her person, and her body was caused due to asphyxia as a result of compression of the air passage in the throat. But there is absolutely no evidence on record to show that the accused person or any of them inflicted the injuries on her person or caused her death by pressing her neck.
Continue, Varun.
My lord. On the other hand, it is revealed from the evidence of PW7 that the accused Bhanu was working as a laborer in the house of PW7 from 7 a.m. onwards on that day. After hearing about the serious condition of Minati, he went from the house of PW7 to his house. In such circumstances, the case, it can never be believed even for a moment that the accused person or any of them caused the death of Minati by assaulting her by pressing her neck. Thus, the charges under Section 302/34 IPC is not sustained against the accused persons.
Deceased was staying in your house and she died this type of, she sustained this type of injuries, and there was hard bone fracture. So under Section 106 of the evidence, as you are required to explain under what circumstance the deceased died. Merely because you have taken a plea that I am working as a laborer, I was in the house of so and so.
My lord, PW7 deposed that he was working as the house of the PW7, not the.
No, that PW7, but how the death took place? If the PM doctor says like this, then and she was staying alone with you at the relevant point of time in that house at so how she sustained injury?
My lord, from the
then it is somebody else who has caused injury, either you or somebody else.
My lord, from
Then
the prosecution case, it is nowhere mentioned that the husband has assaulted or husband was present in the at the time of occurrence or at the time of death. And the three of the at the time of framing investigation, the IO has examined three witnesses, PW 3, 4, and 5, who turned hostile, who deposed that the accused
no, we'll come to that.
PW2, whose house was present in front of the house of the deceased.
The best witness in such type of cases are the family members, the parents or the brothers. They can say, because in your locality, obviously your neighbors would support you. They will not say against. Very rarely the neighbors tell against the person who is accused of the offense. But in view of the nature of injury sustained and the time gap of it is within 1 year and few months.
4 months.
Right. So who are the parents or any family member examined?
My lord, the father is examined as
PW
6.
6.
My lord.
Let us go to that. ଆପଣଙ୍କର ସବୁ କ୍ୱେଶ୍ଚିନ୍ ର ଆନ୍ସର ହଉଛି ଦେଇଛନ୍ତି ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ରେ ମିଛ କଥା। ମିନତି ମଲା ବେଳେ ମୁଁ କାମକୁ ଯାଇଥିଲି, ଘରେ କେହି ନଥିଲେ, ମିନତି କିପରି ମଲା ମୁଁ କହିପାରିବିନି। ତା ଗଳା ଚିପିକି ମରାଇଛି, ତାକୁ ବିଭିନ୍ନ ଜାଗାରେ ମାଡ଼ ହେଇଛି, ବିଭିନ୍ନ କ୍ଷତ ବିକ୍ଷତ ହେଇଛି। ଆପଣଙ୍କ ପାଖରେ ସେ ଏକୁଟିଆ ସେତେବେଳେ ରହୁଥିଲା, ଆପଣ ପ୍ଲି ନେଇଗଲେ କାମକୁ ଯାଇଥିଲି କହିପାରିବେନି। Then somebody else has done this according to you. Why somebody else would assault your wife and compress his neck, her neck, and as a result of which you die? Yes, who is that father?
PW6.
Yes.
This is Minati, is my father. I know the accused person in dock. More than 2 years back in the month of Aswina, Minati died. About 4 years back in the month of Asada, Minati had married to accused Bhanu. At the time of marriage, I had given cash of rupees 7,000 and other household articles. It was decided that I would give a gold chain later, but I could not give her gold chain till her death due to my poverty. S.K.SAHOO had arranged the marriage. He is dead now. Minati was coming to my house from her husband's house at times and telling me to give the gold necklace as she was being treated in her husband's house with cruelty for gold chain. On 2-3 occasions, there were Bhadraloki and the matter was settled, and I left Minati in her husband's house. I have submitted an application before Pad- Padagodi Gram Panchayat to settle the matter. In the meeting of Gram Panchayat, accused Bhanu was told not to ill-treat Minati, and an agreement was written. After the Panchayat meeting, accused Bhanu and Minati remained at Rathipur for some days, and 4 months prior to her death, they were staying in house in village Bodsimulia. She died in the month of Aswina on a Saturday. On that day at 11 a.m., the teacher Vijay Das informed me that Minati had died. Myself and my brother Kailas and Purnachandra went to their house at Bodsimulia. I found that Minati was lying dead on the mat in her house, and accused was present in her house. Accused Bhanu told me that Minati, taking poison, died. There was mark of injury on her neck. Kailas and Purnachandra stayed
This
near.
poison theory is falsified by the C report.
Yes, my lord.
C report at page 69.
My lord.
Common insecticidal, alkaloidal, and metallic poison could not be detected. So that goes. So now focus on that. Your wife was staying alone with you. She has sustained number of injuries on different parts of the body, and her neck was compressed, as a result of which she died. And the background is this demand of chain, and the torture is there, and for which some panchayat was held. So any witness has been examined?
Yes, PW1.
Panchayat विषय को केबे हितला panchayat?
About 15 to 20 days prior to the incident.
Not for them, my lord. There was a near house, Bhaskar Behra, to settle the dispute between one Vishnu Behra and his wife.
Vishnu Behra ki?
The other villager. Tanko panchayat settle kariya pai they were
in that meeting. No, press karantu.
In that meeting, this is Minati told that as she had not brought gold necklace, her husband accused Bhanu was always assaulting her. Accused Bhanu had attended that meeting. We asked accused Bhanu that he should not assault his wife, and their differences were compromised. In that meeting, 15 days thereafter, we received information that the wife of the accused Bhanu died by taking poison. Ramachandra Mahanti, the father of the deceased, was telling me prior to her death that I should keep watch on the deceased and her husband. The cross-examination, para 4. Accused Bhanu belongs to Rothipur, which is 0 kilometers away from our village. Accused Bhanu and his wife were living separately in our house from his parents' house. I was examined by the police. It is not fact that I have not stated to IU that Deceased Minati told before the punch that she was being assaulted by her husband as she had not bought gold necklace from her father's house. It is not a fact that deceased Minati did not tell anything about the gold necklace. After the meeting was over, accused Bhanu and his wife were living happily. Prior to the punch meeting, the father of the deceased Minati was telling me that Minati was being trouble in her husband's house and I should watch their movements and they were living in our village. My lord, the PW1 and PW2 both were present at that meeting. But the
line tap on Pacharle, it's not a fact that I have not stated to the IO that deceased Minati told before the punch that she was being assaulted by her husband as she had not brought gold necklace from her father's house. So this was confronted, her previous statement was confronted. But she stated that, yes, I have stated like that. So now it is to be proved through the investigating officer. Who is that IO?
PW14.
Has it been proved that contradiction? Is this witness is PW1? Okay, PW paragraph 6. PW1, Bansidhar Patra has not stated before me that deceased Minati told before the punch that she was being assaulted by her husband as she has not been. Okay, so this goes. It a first time Koichi court. It's not a fact deceased did not tell anything after the meeting was over. The accused Bhanu and his wife are living happily.
PW2 also was present in that meeting. May I read that question?
Yeah.
I know the accused person in the dock. This is Minati, the wife of the accused Bhanu, about 2 years back in our village. Minati died. 4 months prior to her death, she and her husband were staying in our village. About a month prior to her death, a punch was convened in our village and the meeting was held near my house to settle the dispute between the Vishnu and his wife. In that meeting, Minati told that her husband was assaulting her. Accused Bhanu was present in that meeting. We asked accused Bhanu that he should not assault his wife and both of them should live together. On the day of death of Minati, I returned to village from jungle at about 11 a.m. and heard that Minati had died during the course of investigation. During the course of investigation on the following day of death, police removed the gold and silver ornaments from the dead body and seized the same under the seizure list Exhibit 1. In my presence, Exhibit 1 is my signature and so prepared.
Just a minute. Sivito Kochi Minati told her husband was assaulting and accused Bhanu was present in that meeting. We asked
but
Bhanu.
The demand of chain is not there, my lord.
No, assault part is there.
My lord.
Okay, on the day of the death of Minati, I returned so and so. So this took place about a month prior to the death.
My lord.
Okay, then.
My lord, the cross-examination at para 4. I cannot say if accused Bhanu was staying in our village with his wife, as he did not pull on well with his parents. In the meeting, Minati did not disclose the cause of assault. After the meeting, accused Bhanu and Minati were living happily in our village. The seized ornaments were given to the fathers of the deceased in Jima as he had given to those ornaments.
Okay, Anko, about the family members of the deceased, who has been examined apart from PW6?
My lord, PW10.
Just Mr. Tripathi,
Yes, my lord.
this father's evidence,
Yes.
it indicates that when the dispute arose, it was on account of that gold chain,
Yes.
right?
Yes.
He submitted an application before the Gram Panchayat
Yes.
to settle the matter. And in that meeting, this appellant, he was present and he told that I will not ill-treat the deceased henceforth. And an agreement was written to that effect, right?
Yes, my lord.
So where is that agreement?
Exhibit 10. My lord.
10.
Yes.
Okay. Who has proved that agreement? Because this PW6 has PW exhibit 10 is the Panchayat
Patra.
Patra. ये देखिए exhibit 10 डबार करें. ten exhibit list our.
PW9 proof.
ठीक है. हाँ सर. 10 नंबर. 13 सेटा पड़ेगा बैक करो. हाँ एगुड़ा. एटा डेट दिया है ची 1/6/97 रे. Exhibit 10 रो.
Yes.
So exhibit हाँ पंडा 96 ଆଉ ଥରେ ବାହାର କର ପଡଗଲା. ତାହେଲେ ବି ତଳେ ଲେଖା ହେଇ 97 सिग्नेचर अच्छी 97 रे सीज है. अच्छा ठीक है. ताले एटा 1/6/96 रो. ओके. एग्जिबिट 10 हला 1696. So सेटा होची 96 रो. Just
Yes,
keep
yes.
in mind because the death took place in
97.
right. So आषाढ़ रे 96 रे तांकर बाहागर हेची. सेई
ପରେ ପରେ ହେଇଛି just.
केमती मो आषाढ़टा आपणकर केबे आरंभ हो? आषाढ़टा ऑर्डिनरी
जुलाई.
आरंभ हाँ माने या परे तो रज परे तो माने रज तो रज बेलू तो ज्येष्ठ मास चलता है.
ଜୁନ ତାପରେ ଜୁଲାଇ ଆଷାଢ.
तो 1/6 केमता बाहागर जदी आषाढ़ रे हला ता पूर्वुर केमती मीटिंग टा हेला? ये मीटिंग डेट टा पड़ीची 1/6/96. आपणकर जदी आपन स्टेटमेंट होउची जे जुलाई मासरे आपणकर बाहागर हला.
ବାହାଘର 2 years back ହେଇଛି.
हाँ
2 years back.
2 years back माने केबे
ମାନେ 97 ରୁ ହେଲେ 95 ରେ ହବ.
आषाढ़ 96 परा कहउजन कि ओटा
ନାଇଁ କି
ना ना.
ତା ବାପା ନିଜେ କହୁଛି
प्लीज कम टू दी
My lord,
PW6 who will tell the truth.
एफआईआर को आसुना दी
FIR.
आपण. एफआईआर पर लिखा
Around
है जी
5th line.
एफआईआर इज लॉस्ट बाय हु इज द फादर.
Father.
मोर एई मौखिक जे कि मोर झियो मिनती बयस 21 को गत 1996 मसीहा आषाढ़ मास अर्थात आज को प्राय 1 वर्ष 4 मास तले बाहागर देइथि. से जो 2 वर्ष कहूची सेटा डिपोजिशन बेलू 2 वर्ष
2
तले
ବର୍ଷ.
एफआईआर देला बेलू. तेणु बाहागरटा डेटटा होउची आषाढ़र 96 मसीहा रे. जदि आषाढ़ 96 मसीहा रे बाहागर हेला ए डॉक्यूमेंटटा जो आनिकिनी प्रोसिक्यूशन प्रमाण करूची जे ताकू गोटे निर्यातना हेला बेली 1/6/96 रे गोटे मीटिंग हेला. हाउ इज इट पॉसिबल that prior to the marriage how can be you produce a document that there was a meeting on account of dispute? प्रथम पक्ष सुवांशु द्वितीय पक्ष ये प्रथम पक्ष सुआंशो आदि लिखाई 27/5/97 तारीख दिन घरोई गंडगोल तार सासू शशुर नणंद को नहीं होइथिला एतादृश गंडगोल आपण देखिलेनी लेटर टा एई देटा को देखिलो सेठी सेपडू डिस्प्ले करो से मन देखुन और ये प्रिंट आउट काढी दियो अदल पढंतु आपण दियंतु प्लीज वेरीफाई ईच लाइन फास्ट देखंतु ऊपर केबे से मीटिंग हेइची 96 राइट सेतबळକୁ बाहागर हेइनी आपण को कहवा अनुଯାयी तापर देखंतु 1/96 रे जदी मीटिंग हला ता देर लेखा होची कोन ना प्रथम पक्ष मिनती आसी कहिला जे 27/5/97 तारीख दिन घरोई गंडगोल जोगु ता सासुर कि 96 तो मीटिंग हला 97 रे कोन गंडगोल केमती हला से विषय केमती उल्लेख हला प्रथम पक्ष मिनती प्रधान स्वामी भानु प्रधान 27/5/97 रे घरोई गंडगोल तांको सासू ससुर नणंद को नहीं होइथिला एतादृश गंडगोल को नहीं प्रथम पक्ष 27/5/97 तारीख दिन कप्तिपदा थाना रे मोर ससुर सुआंशो को ना रे एक मोकदमा रुजु करथिले उक्त मोकदमा स्थानीय सरपंच को परामर्श मोकदमा को निज निज मध्य आपस समाधान करिया पई दायित्व देथिले अद्य 1/6/97 अच्छा पुणी कौन 97 लिखलानी तो ये जो ऊपर डेटा बोधे भूल ले लिखा है हाँ एटा बोधे 1/6/97 हाँ ये दिबा 97 हेले ठीक आसुची हाँ एग्जिबिट 10 जो ऊपर लिखा है इट शुड बी हाँ सेटा भूल लिखा है सो इट इज 1697 उभयों को मध्य रे शर्तावली अच्छा ये जो हेइथिला आपनकर से विषय मध्ये से क्वेश्चन पचार जे मीटिंग टा कोन पे हेइथिला जे घरोई गंडगोल को नहीं हला तांकर सासू ससुर नणंद को नहीं होइथिला हला एई गंडगोल को नहीं प्रथम पक्ष कप्तिपदा थाना रे सासू ससुर नणंद को ना रे एतला देइथिले एवं परामर्श क्रमे स्वांशो से हस्बैंड रे सेठी किछि रोल नाही घरोई गंडगोल हला एगेंस्ट फादर इन लॉ मदर इन लॉ एंड सिस्टर इन लॉ राइट आपो समाधान हे गला अद्य 1/6/97 रे दिबा 9टा समय रे कार्यालय गृह रे निम्नलिखित भद्रलोक तथा उभय पक्षों उपस्थित रे निम्न मते समाधान करिथिलु उक्त समाधान को उभय पक्ष सादरे ग्रहण कले 1 नंबर सत्य रहिला 1/6/97 तारीख उभय झियो श्री मिनती प्रधान स्वामी सुआंशो उभय गहिरा ससुर घर को सम्माने जीवे अच्छा 2/6/97 दिन ठारू 10/6/97 भितरे स्वामी स्त्री भुवनेश्वर रहउथिबारु झियो केबे सठिक अच्छा ता बाप घर बोधे सेठी जाइकिनी सेठी रहिबो भानुचरण प्रधान मासकु 2-3 थर घर को जीवा आसीबा करिवे घर समस्त कथा बुझिवे आसंता 10/10/97 तारीख रे तांको स्वामी भानुचरण जोठी रहिबे तांको स्त्री मिनती प्रधान को सेठारे रखिबे आउ तांको स्वामी सासु मध्य रे जेपरि कोनोसी प्रकार गंडगोल न हुए सेथि पई द्वितीय पक्ष ससुर सुआंशो को दायी रखिबे बहु मिनती प्रदान घर समस्त सदस्यों कथा मानि चलिबे उपरोक्त शर्त मध्य सो एई जो चिठीटा आपण एई जो गोटे पंचायत पत्र आपण प्रमाण कले इट गोज इन फेवर ऑफ द अपेलेंट एइथ पई ଯେ ଯୋଉ କଳିଟା ହେଇଥିଲା ଡିସିଜ୍ ର ସେଇଟା ହେଇଥିଲା ତା ଶାଶୁ ଶ୍ୱଶୁର ଆଉ ନଣନ୍ଦ ସହିତ ଏବଂ ଦ୍ୟାଟ୍ ୱାଜ ସେଟଲ୍ ହେଲା। ସେଇଥିପାଇଁ ସେମାନେ ଡିସାଇଡ୍ କଲେ ଯେ ନାଇଁ ସିଏ ଅଲଗା ହେଇ ରହିବେ। ତେଣୁ ଯେହେତୁ ସ୍ୱାମୀ ଭୁବନେଶ୍ୱରରେ ଚାକିରି କରୁଥିଲା ଅର୍ଥାତ୍ ଆପେଲାଣ୍ଡ, ତେଣୁ ଝିଅ ଯାଇକିନି ପ୍ରଥମେ ଆଗେ ରହିବ ଏଠି ତା ବାପ ଘରେ ରହିବ ହେଲା। ଇଏ ସ୍ୱାମୀ ଆସିବ ମଝିରେ ମଝିରେ 2-3 ଥର ଦେଖା କରିବ ତାକୁ। ତାପରେ ଘରେ ଯେତେବେଳେ ବୋଧେ ସେ ଯୋଉ ଜାଗା ଯେତେବେଳେ ସେ ଘର ଠିକ କରିଦବ ସେଠି, ତାପରେ ସିଏ ତାକୁ ଯାଇକିନି ସିଏ ରହିବେ। ତାପରେ ସ୍ୱାମୀ ନେଇକିନି ଯେଉଁଠି ରହିବେ ସେଠି ରହିବ, ମାନେ ପର୍ପସ ହଉଛି ଏଇଆ ଭୁବନେଶ୍ୱରରେ। ଏବଂ ତାପରେ ବାକି ସମ୍ପର୍କ ଠିକ ରଖିବେ ବୋଲି ଏସବୁ ଏଇ ଯୋଉ ଜିନିଷ ହେଲା। ସୋ ଦିସ୍ ଲେଟର which is dated 1/6/1997 and that is about 2.5 months let us say, বা 3 মাস হয়ে যাও 1/6/1/7 ହଁ almost 3 ମାସ ପୂର୍ବରୁ 3 ମାସ ପୂର୍ବରୁ ଏଇ ଚିଠିରୁ ଜଣା ପଡୁଛି ଯେ ଆଟଲିଷ୍ଟ ହଜବ୍ୟାଣ୍ଡ ନାଁରେ କିଛି କମ୍ପ୍ଲେନ ନଥିଲା। And much less to say about demand of dowry by not only the husband but any of his family members. କାରଣ ଯୋଉ ମିଟିଂଟା ହେଲା ସେଟା ଘରୋଇ କଳି ପାଇଁ, ସେଟା ନୁହେଁ ଯେ ଯୌତୁକ ଦାବି ପାଇଁ, right? Okay, now you come to again to the evidence of that PW6. ଆଚ୍ଛା, ଆପଣଙ୍କ ତରଫରୁ ଯୋଉ ଚିଠି ଗୁଡାକ ପ୍ରମାଣ କରେଇଲେ ଯୋଉଡାକ ସେ ଲେଖିଥିଲା ମାନେ ଡିସିଜ ଲେଖିଥିଲା, let us come go through that.
Para 2 of the cross examination.
Huh?
Cross examination, para 2, page 45 of the paper book.
ହଁ, କଣ ଲେଖା ହେଇଛି?
ସେ ଚିଠି ଗୁଡାକୁ ସେଠି
ନା ଆମେ ଚିଠି ଗୁଡା ଦେଖିବା ନା, ସେ କଣ ପ୍ରଥମ ଚିଠି ହଉଛି exhibit 4 ଗୋଟେ ଚିଠି written by Minati to me. 4 ଟା ବାହାର କଲ।
4, 5, 6, 7, 8, 9.
रो ସେଟା 2 3 ତାପରଟା, ଆରେ ତା ପରଟା ତା ପୂର୍ବଟା କଣ? ହଁ ଏଇଟା ଅଛି। ଏଇଟାର ଗୋଟେ କପି ତମ କରିକି ଦେଲେ ନା, ଏଇଟା ବାହାର କଲେ ଏକ୍ସିବିଟ୍ 4 ଟା ତାଙ୍କୁ ଦିଅନ୍ତୁ, ଷ୍ଟେଟ୍ କାଉନସିଲକୁ ଦିଅନ୍ତୁ। ଏ ଚିଠି ଡିସିଜ ଲେଖିଛି ବାପା ପାଖକୁ, ପଢନ୍ତୁ। ଯୋଉଟା ଆପଣଙ୍କ ତରଫରୁ ଏକ୍ସିବିଟ୍ ହେଇଛି। ହଁ, ପୂଜନୀୟ ବାପା ପଢନ୍ତୁ।
ପୂଜନୀୟ ବାପା, ମୋର ଭୂମିଷ୍ଠ ପ୍ରଣାମ ଗ୍ରହଣ କରିବ। ଲେଖିବାର କାରଣ ଏଇକି ଯେ ମୁଁ 8 ଦିନ ହେଲା ବିଲକୁ ଯାଉଛି, ମତେ ପିଟା ଟଣା କରି ବିଲକୁ ନେଇ ଯାଆନ୍ତି। ପଣା ଦିନ ନ ଯିବାରୁ ମତେ ସେଦିନ ବହୁତ ପିଟା ଟଣା ଘୋଷାଡ଼ି ମରା କରିଛନ୍ତି। 2 ତାରିଖ ଦିନ ଧାନ 1 ପାଉତି ଆଣିଥିଲି। 12 ତାରିଖ ଦିନ ସରିଲା, ମତେ କହୁଛନ୍ତି ଯେ ଚାଉଳ ବିକି ଦେଉଛୁ ଓ ଗୁଡାକୁ ଖାଇ ଦେଉଛୁ। ହେତୁ ବହୁତ ଜାଣି ପାଟିତୁଣ୍ଡ ହଉଥିବାରୁ ସେମାନେ ଡରୁଛନ୍ତି ଯେ କହୁଛନ୍ତି ଯେ ତୋର
ବ୍ୟବସ୍ଥା
କର। ଆମେ ଆଉ
ଖାଇକି
ମାନେ ଖାଇବାକୁ ଦେଇପାରିବୁ ନାହିଁ, ଖାଇତେ ଦେଇପାରିବୁନି।
ତମର ବ୍ୟବସ୍ଥା କରିଦେଇ ଦିଅ ଏବଂ ମୋର ଅସୁବିଧା ନହେଲେ ଦୁଇ ଧରି
ମୁଁ ବିଲକୁ ଯିବାରୁ ମୋର
ମୋ ଦେହ ହାତ ଗୋଡ ରାତିରେ ବହୁତ ବିନ୍ଧା ଗୋଳା କରୁଛି। ମୁଁ କହିଥିଲି ଯେ ମୁଁ ବିଲକୁ ଯାଇପାରିବି ନାହିଁ, ମତେ ଘୋଷାରି ନେଇ 8 ଦିନ ହେଲା ବିଲକୁ ନେଉଛନ୍ତି। ଏହି ଚିଠି ପାଇ ଶୀଘ୍ର ଆସିବ, ତେଣି ଲେଖି କରିବ ନାହିଁ, ଡେରି କରିବ ନାହିଁ। ମତେ 3-4 ଦିନ କାଳ ରକ୍ତ ଝାଡା ହେଉଛି, ମତେ ଔଷଧ ଆଣି ଦେଉନାହିଁ, ମୋର ଦେହ ହାତ ଭଲ ଲାଗୁନାହିଁ। ସେହି ସବୁ ଦେଖି ବିଲକୁ ନେଉଛନ୍ତି।
ଏଇ ସବୁ ଦେଖି ବିଲକୁ ନଉଛନ୍ତି, ମାନେ ଏଇ ସବୁ okay, then this of course goes against okay, next letter is PW exhibit हाँ accused भानु को मिनती गुड़ा कौन ଅଛି 5 टा देखिले कौन लिखे accused भानु माने petitioner appellant लिखिथिला
wife
नहीं to me माने PW6 को
no
अरे
exhibit 5 ଟା ହଉଛି the letter issued by accused Bhanu to Minati.
exhibit 5
yes
अच्छा हो हाँ हाँ मीनू हाँ पढ़न
ମୋର ସ୍ନେହ ନବୁ, ଘରେ ବାପା ବୋଉଙ୍କୁ ମୋର ଭୂମିଷ୍ଠ ପ୍ରଣାମ ଏବଂ ଭାଇ
ମାନେ
ଭାଉଜ
ଏଇ ଯୋଉ ଝିଅ ଅର୍ଥାତ ଡିସି ସେତେବେଳେ ରହୁଥିଲା ତା ବାପ ଘରେ
yes
ଇଏ ଆପେଲାଣ୍ଟ ତାକୁ ଚିଠି ଲେଖିଛି ହଁ ପଢନ୍ତୁ
ଘରେ ବାପା ବୋଉଙ୍କୁ ମୋର ଭୂମିଷ୍ଠ ପ୍ରଣାମ, ମୋର ଭାଇ ଭାଉଜଙ୍କୁ ପ୍ରଣାମ ଏବଂ ସୁଙ୍ଗକୁ ମୋର ସ୍ନେହ ଜଣାଇଦେବୁ। ରଙ୍ଗକୁ ଆଶା କରେ ଠାକୁରଙ୍କ କୃପାରେ ସମସ୍ତେ ଭଲରେ ଥିବ। ମୁଁ ଏଠାରେ ଭଲରେ ଅଛି। ମୁଁ ଏଠି ଆସି ସନ୍ଧ୍ୟା 7ଟା ବେଳକୁ ପହଞ୍ଚିଥିଲି। ଲେଖିବାର କାରଣ, ମୁଁ ଘରକୁ ଗଲାବେଳେ ମୋ ଦରମାର ଆଡଭାନ୍ସ ନେଇ ଯାଇଥିଲି, ତେଣୁ ମୋ ପାଖରେ ଚଳିବା ପାଇଁ କମ ପଇସା ଅଛି ଏବଂ ମୁଁ ଯେଉଁ କଥା ତତେ କହିଥିଲି ସେଥିପାଇଁ 500 ଟଙ୍କା ଦରକାର ହେଉଛି। ମୋ ପାଖରେ ତ ଏବେ ପଇସା ନାହିଁ, ତେଣୁ ତୁ ଯଦି ଘରେ ବାପାଙ୍କୁ କହି ମୋ ପାଇଁ ଯୋଗାଡ଼ କରିପାରୁଛୁ।
500 ଟଙ୍କା ନୁହେଁ ମ ଏଇଟା 15,000 ଟଙ୍କା ବୋଧେ 1,5,15,500 ନା କଣ ଲେଖା ହେଇଛି କି 15,000 ଟଙ୍କା ଏଟା ସେଇ ବିଷୟରେ ମଧ୍ୟ ସେ କହିଛି। ହଁ ଏଟା 15,000 admit ମଧ୍ୟ କରିଛି cross examination in exhibit Swanso accused Bhanu had requested to give him 15,000 okay ହଁ 15,000 ଟଙ୍କା ହଁ ପଢି ଯାଆନ୍ତୁ।
ମୋ ପାଖରେ ଏବେ ଏତେ ପଇସା ନାହିଁ, ତେଣୁ ତୁ ଯଦି ଘରେ ବାପାଙ୍କୁ କହି ମୋ ପାଇଁ ଯୋଗାଡ଼ କରିପାରୁଛୁ ତେବେ ମୁଁ ଖୁସି ହୁଅନ୍ତି ଏବଂ ଘରେ ଆଉ ସମସ୍ତଙ୍କ ଖବର, ତୋର ଦେହ କେମିତି ଅଛି ମୋ ପାଖକୁ ଚିଠି ଦ୍ୱାରା ଜଣାଇବୁ। ଯଦି ସୁବିଧା ହେବ ତେବେ ମୋ ପାଖକୁ ଟଙ୍କା ନେଇ ଯାହାକୁ ପଠାଇବୁ, ମୁଁ ଦରମା ପାଇଲେ ସୁଝିଦେବି। ମୁଁ ରଥିପୁର ବାପାଙ୍କ ପାଖକୁ ପଇସା ପାଇଁ କହିଥିଲି, ତେଣୁ ବାପା ପାଇଁ କିନ୍ତୁ ବାପା ଗାଈ ବିକ୍ରି କରି ପଇସା ଦେବାକୁ କହିଲେ, ତେଣୁ ତୁ ଯଦି ସୁବିଧା କରିପାରିବୁ ମୁଁ ସୁଧ ସହ ଫେରାଇ ଦେବି। ଚିଠି ପାଇ ଚିଠି ଦବୁ।
ତ ଏଇଟା is a normal letter, is not a demand 15,000 those he asked for 15,000 she request कला जो टाइप रो कम्युनिकेशन ହେଇची स्त्री रो स्वामी भितरे ये तो देखुची गोटे कॉर्डियल रिलेशनशिप थिला जे ताକୁ रिक्वेस्ट करची बापाटू मोर वर्तमान एई असुविधा रहिची मते आनिकिनी 15,000 टंका आनिकिनी व्यवस्था कले मु सुध सह फेरई देबी आ मु मो बापा को कहितली बापा कहले गाई बिकिବାକୁ पड़ियो मु ताଙ୍କୁ मना कली। So this is the letter of the appellant to the deceased.
yes
Okay, next letter एटा कोनटा exhibit 6 एटा की कागु लिखतला ए appellant लिखितला
yes appellant to the
PW6 हाँ PW6 पढ़ंतु।
ପୂଜନୀୟ ବାପା ଭୂମିଷ୍ଠ ପ୍ରଣାମ ଗ୍ରହଣ କରିବେ। ବୋଉଙ୍କୁ ମୋର ପ୍ରଣାମ ଏବଂ ରଙ୍ଗ ବାପି ମୁନା ଜଣାଇଦେବେ। ମୁଁ ଏଠାରେ ଏକ ପ୍ରକାର ଉତ୍ତର ଭଲରେ ଅଛି। ଆଶା କରେ ଠାକୁରଙ୍କ କୃପାରୁ ତୁମେ ସମସ୍ତେ ଭଲରେ ଥିବ ବୋଲି ଆଶା ଓ ବିଶ୍ୱାସ। ଲେଖିବାର କାରଣ, ମୁଁ ଏଠି ଆସି ଭଲରେ ପହଞ୍ଚିଲି, ଏବେ ସବୁ କାମ ଠିକରେ ଚାଲିଛି। ଫ୍ୟାକ୍ଟ୍ରି ଚାଲିଲା ବେଳକୁ ଆଉ 2-3 ମାସ ଲାଗିପାରେ। ମୁଁ ଏବେ ଘରକୁ ଆସିପାରିବିନି, ତେଣୁ ତୁମ ଖବର, ଗାଁର ଖବର ଏବଂ ଆମ ଘର ଖବର ଚିଠି ଦ୍ୱାରା ଜଣାଇବ। ବିଲବାଡ଼ି କାମ କେତେ ବାଟ ଗଲା, ତୁମ ଝିଅର ଦେହ କେମିତି ଅଛି ଏବଂ ରଙ୍ଗକୁ କଣ କହିବାର ଥିଲା କହିଲା କି ନାହିଁ ମତେ ଜଣାଇବ। ମୋ ପାଖକୁ ଚିଠି ଲେଖିକି ବୋଉର ଅବସ୍ଥା କେମିତି ଅଛି ଏବଂ ଆମ ବିଲ ଚାଷ ହୋଇଛି କି ନାହିଁ ଏବଂ ଆମ ଘର ଆଡେ ମଝିରେ ମଝିରେ ଆସୁଥିବ, ଏତିକିରେ ରହିଛି।
ये कौन है? तो पूरा नॉर्मल चिट्ठी।
Normal चिट्ठी, yes.
Yes. Then next
7 exhibit.
exhibit 7 टा एटा की काबू लगी?
Accused value to wife.
Accused to the deceased. Okay. पढ़ନ୍ତୁ।
ମୋର ସ୍ନେହ ନବୁ, ବାପା ବୋଉଙ୍କୁ ମୋର ପ୍ରଣାମ। ଅଂଶୁ ମୋର ସ୍ନେହ ପଠାଇଦବୁ। ଠାକୁରଙ୍କ କୃପା ମୁଁ ଏଠାରେ ଭଲରେ ଅଛି। ଆଶା କରେ ତୁମେମାନେ ସମସ୍ତେ ଭଲରେ ଥିବ। ଲେଖିବାର କାରଣ ଏଇକି ମୁଁ ଘରୁ ଆସିବା ପରଠାରୁ 8 ଦିନ ପର୍ଯ୍ୟନ୍ତ କିଛି କାମ କରିବା ପାଇଁ ଖୋଜି ବୁଲୁଥିଲି ନିଶ୍ଚୟ, କିନ୍ତୁ ଭଗବାନଙ୍କ ଆଶୀର୍ବାଦରୁ ମୁଁ ଏବେ ଗୋଟେ ଭଲ ଚାକିରି ପାଇଛି। ଏଇଗୁଡ଼ା ନୂଆ କମ୍ପାନୀ ଆରମ୍ଭ ହେଉଛି, ଆଉ 4 ମାସ ପରେ ଆରମ୍ଭ ହବ। ସେତେବେଳକୁ ମତେ ଭଲ ଦରମା ମିଳିବ ଏବଂ ମୁଁ ଭଲରେ ଅଛି। ମୁଁ ଆଉ ଗୋଟିଏ ଚିଠି ପଠାଇଥିଲି କିନ୍ତୁ ଉତ୍ତର ଆସିଲା ନାହିଁ। ମତେ ଏବେ ଘରକୁ ଯିବାକୁ ଛୁଟି ମିଳିବ ନାହିଁ। ଆଉ 4 ମାସ ପରେ ଛୁଟି ମିଳିବ। ମୋର ଲେଖିବାର କାରଣ ଏଇକି ଥିଲା ଯେ ତୁମ ଘରର କୌଣସି ଲୋକ ମୋ ବାପ ବୋଉଙ୍କୁ କୌଣସି କଥା କହିବା ଦରକାର ନାହିଁ। ମୁଁ ତତେ ତୁମ ଘରେ ଛାଡି ଆସିଛି ଏବଂ ମୁଁ ନିଜେ ଯାଇ ନେଇ ଆସିବି। ତେଣୁ କୌଣସି ପ୍ରକାର ବ୍ୟସ୍ତ ହେବା ନାହିଁ। ତୁ ଏବେ ତୁମ ଘରେ ରହୁଥିବୁ ଏବଂ ଘରେ ଜଣେଇଦବୁ ଯେ ଦୟାକରି ମୋ ବାପା ବୋଉଙ୍କ ସାଥିରେ କୌଣସି ଝଗଡ଼ା ଯେମିତି ନ ହୁଏ। ଏମିତି କୌଣସି ଖବର ମୁଁ ଶୁଣିଲେ ଭାବିନେବି ଯେ ମୁଁ ଆଉ ଘରକୁ ଆସିବି ନାହିଁ। ଦେଖ, ମୁଁ ହଉଛି ମୋ ବାପା ମାଙ୍କର ଗୋଟିଏ ବୋଲି ପୁଅ। ତାଙ୍କର ସମସ୍ତ ଆଶା ପୂରଣ କରିବା ହେଉଛି ମୋର କର୍ତ୍ତବ୍ୟ। ଆଉ ତୁ ମୋ ସହିତ ପାଦ ମିଳାଇ ଚାଲେ, ଆମ ଜୀବନଟା ନିଶ୍ଚୟ ସୁଖମୟ ହେବ। ଏଣୁ ଜମା ବ୍ୟସ୍ତ ହେବୁ ନାହିଁ, ମୁଁ ଶୀଘ୍ର ଆସିବି। ଏତିକିରେ ରହିଲି।
It's normal letter. Next letter.
Exhibit 8.
हाँ, पढ़ନ୍ତୁ।
ମେନୁ ମୋର ଶୁଭେଚ୍ଛା ଏତିକି। ମୁଁ ପ୍ରଣାମ ଜଣାଇଦେବୁ। ଏତିକି।
ମାଇକ୍ ଟା କୁଆଡେ ରଖିଛନ୍ତି କି?
ପ୍ରଣାମ ଜଣାଇଦେବୁ। ରଙ୍ଗ ବିପୁଳ ମୋ ସ୍ନେହ ଜଣାଇଦେବୁ। ଲେଖିବାର କାରଣ ମୁଁ ଘରୁ 2 ମାସ ହେଲା ରାଗି କରି ପଳାଇ ଆସିଅଛି। ବର୍ତ୍ତମାନ ମୋର ସେଠାକୁ ଯିବାର ନାହିଁ। ବର୍ତ୍ତମାନ ମୁଁ ଗୋଟେ ଘରୋଇ କମ୍ପାନୀରେ କାମ କରୁଅଛି। ଏଠାରେ ଯାହା ପଇସା ପତ୍ର ପାଉଅଛି ମତେ ନିଅଣ୍ଟ। ମୁଁ ଏଠାରେ ଆଉ ଗୋଟେ ଚାକିରି ବୁଝିଅଛି, କିନ୍ତୁ ଡୋନେସନ 15,000 ଟଙ୍କା ପଡିବ। ତୁ ଯୋଗୁ ମୋ ହାତରେ ଗୋଟେ ପଇସା ନାହିଁ।
ତୁ ତ ଜାଣୁ ମୋ
ତୁ
ହାତରେ
ତ ଜାଣୁ ମୋ ହାତରେ ଗୋଟିଏ ପଇସା ନାହିଁ। ତେଣୁକରି ତୁ ତୋ ବାପାଙ୍କୁ ଭାଇକି କହି ମତେ 15,000 ଟଙ୍କା ଦେଇଥିବେ। ମୁଁ ଚାକିରି କଲା ପରେ ଆସ୍ତେ ଆସ୍ତେ ତାଙ୍କ ଟଙ୍କା ସୁଝିଦେବି। ମୁଁ 2 ମାସ ସମୟ ନେଇଅଛି। ତେଣୁକରି ତୁ ତୋ ବାପାଙ୍କୁ ଭାଇଙ୍କୁ କହି ଯେମିତି ହେଲେ ଟଙ୍କା ରଖିଥିବୁ। ମୋର ଆଉ କିଛି ଉପାୟ ନାହିଁ। ଆଉ ତମ ଘର ହିଁ କେବଳ ମୋର ସାହା ଭରସା। ଆଉ ତୋ ବାପା ଭାଇ ମାନେ ହିଁ ମୋର ଭରସା। ଯଦି ସେମାନେ ଏ ବେଳରେ ମୋ ପାଖରେ ଛିଡା ହେବେ ନହେଲେ ମୋର କିଛି କରିବାର ଶକ୍ତି ନାହିଁ। ଏ ଚାକିରି ଯଦି ହାତଛଡା ହୁଏ ତାହେଲେ ଆମ ଜୀବନ ସବୁଦିନ ପାଇଁ ଆମେ ହଇରାଣ ପାଉଥିବା। ତେଣୁ କରି ତୁ ବାପାଙ୍କୁ ଭାଇଙ୍କ ଠାରୁ ସମସ୍ତ କଥା ବୁଝି ମୋ ପାଖକୁ ଚିଠି ଦେଲେ ମୁଁ ଯିବି। ମୁଁ ଆଗରୁ 2 ଥର ଚିଠି
2 ଖଣ୍ଡ ଚିଠି ଲେଖିଲିଣି।
2 ଖଣ୍ଡ ଚିଠି ଲେଖିଣି। ତାର ଉତ୍ତର କିଛି ଉତ୍ତର ମୁଁ ପାଇ ପାରୁନାହିଁ। ମୁଁ ଏପ୍ରିଲ ମାସରେ ଯିବି। ଟଙ୍କା ଯୋଗାଡ଼ କରିଥିବ ମୋ ବାପାଙ୍କୁ ଯେମିତି ହେଲେ ଚିଠିରେ ଜଣାଇଲେ ମୁଁ ଯିବି।
ବାପା ବୋଉଙ୍କ ଦେହ ପା କିପରି ଅଛି?
ଦେହ ପା କିପରି ଅଛି? ତୋ ଦେହ କିପରି ଅଛି? ମୋ ପାଖକୁ ଲେଖିବୁ। ଆଉ କଣ ଲେଖିବି?
ଆଶା କରେ ଭଗବାନଙ୍କର ଆଶୀର୍ବାଦରୁ ତମେ ସେପଟେ ଅଛି ନା, ମାନେ ଭଲରେ ଥିବ।
Not next page is not.
ହଁ, ସେଟା ଅଛି। ସେପଟ ପେଜରେ ଅଛି। ସେଇ ତାରି ଏଠି ଅଛି। ମୁଁ ଯୋଉ ଅବସ୍ଥାରେ ଅଛି ସେମାନେ ନ ଜଣେଇବା ପାଇଁ ମୋ ପାଖକୁ ଯେତେ ଶୀଘ୍ର। ସୋ ମିଷ୍ଟର ତ୍ରିପାଠୀ, ସିଏ ଯଦି ଚାକିରି ରେ ତାର ଡୋନେସନ ଦବାକୁ ତାର ଦରକାର ଅଛି ସେ କହୁଛି
15,000
ମତେ
ଟଙ୍କା।
15,000 ଟଙ୍କା ଦିଅ ମୁଁ ପରେ ଚାକିରି କଲା ପରେ ଯୋଗାଡ଼ କରିଦେବି whether it will come within the definition of
Dowry.
demand of dowry.
No, madam. That's not.
So what you are required to prove under 304B that in connection with demand of dowry there was cruelty or torture and soon before her death, that is another aspect. तो ए ingredients काहे एठी आपनकर ए चिठी पर आउ तो चिठी नाही
ना।
सो आपनकर जो ग्राम पंचायत रो गोटे गोटे आसंतु प्रथम हैला से ग्राम पंचायत रे मीटिंग हेइतला
Yes.
से ग्राम पंचायत मीटिंग रे तार अभियोग थिला ता सासु ससुर आ ननंद कनारे ठीक सेठी रादर कुहा गला जे तू जाई पिटिशनर पाखरे रहिबो एवं से बाकी जेतिक चिट्ठी से पढ़िला माने प्लेस हला सब गुड़ाक नॉर्मल एक्सेप्ट गोटे चिट्ठी जोड़ा की ता बापा पाखु लिखिची जे मते से जो कोन बिलो को नेकिनी से जो हां सो से चिट्ठीटा पर्टिकुलरली आनिले आमे खेडा केबे हेइथिला
But the letter of the panchayat whose application was made to the panchayat.
हां
That will be read.
कोडा
Exhibit 9.
एग्जिबिट 9 हो देखन एटा की लिखतला
बापा रामचंद्र महांती informant PW6
कौन सी लिखतला
निवेदन कारण यही कि आम स्त्री आम्बे श्री
छोड़ा था।
रामचंद्र महांती झील मिनती प्रधान को भानुचरण प्रधान वैदिक रीति विवाह देइथिले मात्र विवाह 4-5 मास पर मो झील को सासू ससुर नणंद तथा तार स्वामी बहु बार निर्यातना देवा संगे संगे गत 27/5/97 दिन मो झील को नाना निर्यातन दे घर बाहर कर देइथिले आंभर जोई मो झील को छाड़ी भुवनेश्वर रहुथिले गत 27/5/97 दिन मो झील को माड़ मारी घर बाहर कर देइथिले बारंबार अधिक यौतुक दाबी कर झील ऊपर निर्मम अत्याचार कर बाहर कर देइथिले
एटा केबे कर ये
एटा दे देइछु
सी एटा केते नंबर एग्जिबिट हेची एग्जिबिट
Exhibit 9
9 एग्जिबिट 9 विषय PW6 कोन कहूची ता निजो एप्लीकेशन एग्जिबिट 9 इज द एप्लीकेशन व्हिच आई सबमिटेड बिफोर पगड़ी ग्राम पंचायत अच्छा क्वेश्चन कोन पचराई जी तापरे अच्छा इन एग्जिबिट 9 देयर इज नो मेंशन दैट फॉर द गोल्ड चेन माय डॉटर वाज बीइंग टॉर्चर ही एडमिट्स दैट
yes
ओके आपनकर केस होची प्रोसिक्यूशन केस बा PW6 हु इज द फादर तांकर केस होची जे गोल्ड नेकलेस पाई डिमांड पाई निर्यातना होतिला that is not there in that letter
no
right
Application also the appellant was not present.
huh
In application also appellant was not present. But appellant was staying in Bhubaneswar.
हाँ appellant तो भुवनेश्वर रहुथिला एवं बाकी जो एई पर्टिकुलरली ए चिठीटा भी केबे लेखाई जी किछि जणा पडुनी कारण डेट नाही सी भी किछि कहूनी एंड 27/5/97 तारिख दिन मोर झियो को
27/5 दिया ହେଇଛି ତାଙ୍କର ଫଇସଲା ହେଇଛି 1/6/97 ରେ
जस्ट अ मिनट
27/5 ର ଇନସିଡେଣ୍ଟ ବିଷୟରେ ଡିସ୍କସ
27/5 हाँ
तत्काल लेटर में भी 27/5
अच्छा ठीक है 27 तामने गत 27 माने एटा 27/5/97 परे दिया ହେଇଛି राइट सो ता ऊपर डिसीजन निहाला कोथरे ए जो एग्जिबिट 10 रे हां
पंचायत पत्र
10 आसिला ओ से जोटा हमें पढुथिल हां हां ସେତେବେଳେ ତ ତାକୁ କୁହାଗଲା ଯେ ତୁ ଯାଇକିନି ସି ଯିବ ଝିଅ ଯିବ ବାପ ଘରେ ରହିବ ସ୍ୱାମୀ ଯିବ ଭୁବନେଶ୍ୱରରେ ମଝିରେ ମଝିରେ 2-3 ଥର ଆସିବ ମାସକୁ ଏବଂ ଯେତେବେଳେ ଘର ଠିକ ଠାକ ହେଇଯିବ ତା ସ୍ତ୍ରୀ କି ତା ପାଖକୁ ନେଇଯିବ ଏହା ହିଁ ସମାଧାନ ହେଲା ଆଉ एंड एई डिसीजन टा जदि आपणकर आपण डेट कहउचंती जे 1/6/97 रे नियागला डेथ हैला 27/8/97 तामाने पाखापाखी तार 3 मास परे
Yes.
so if there is no material that during this period
Yes.
after the decision was taken when the deceased went to her house and the appellant went to Bhubaneswar hala there was no torture no cruelty so how you fulfill the one of the ingredients of section 304b that soon before her death she was subjected to torture in connection with demand of dowry soon before ଗୋଟେ କିଛି definition ନାହିଁ ଯେ ସେମିତି ଏତିକି ଦିନ ହେଇଥିବ but there are something to show that କାରଣ ତାପରେ ଆପଣଙ୍କର ବୋଧେ ଏଭିଡେନ୍ସ ଆସୁଛି ଯେ ସେମାନଙ୍କର ସମ୍ପର୍କ ଭଲ ଥିଲା ଇଏ ଥିଲା
ସେମାନେ ଗୋଟେ ଘରେ ରହୁଥିଲେ
ହଁ ତାପରେ କାରଣ ଲେଟର ଯୋଉ ଗୁଡାକ ଏଇ ଯୋଉ ଲେଟର ଗୁଡାକ ଲେଖା ହେଇଛି ଯୋଉଟା ପ୍ରମାଣ କଲେ ଏଗୁଡା କେବେକାର ଲେଟର ସବୁ ତା ପୂର୍ବର ଆଚ୍ଛା ହଁ ଗୋଟେ ଅଛି ଆଚ୍ଛା ଏଇଟା ଫେବୃଆରୀ ମାସ so ଦିଟା କଥା ମିଷ୍ଟର ଲେଟ୍ ଅସ୍ ସେ ପୁରୁଣା ଯାହା ହେଇଥିଲା ସେଥିରେ ତ ବିଶେଷ କିଛି ନାହିଁ ଗୋଟିଏ ଖାଲି ଅଛି ସେ ଝିଅ ଯୋଉ ଲେଖିଥିଲା ବିଲକୁ ନଉଥିଲା ବାକି ଗୋଟେ ମିଟିଂ ହେଲା ବାପାର ଆପ୍ଲିକେସନ ଉପରେ ବାପା ଯୋଉ ଆପ୍ଲିକେସନ ଦେଲା ତା ଦେହରେ ମାନେ ଏଇ ଯୋଉ ସୁନା ଚେନ୍ କଥା ସ୍ପେସିଫିକାଲ ଲେଖା ହେଇନି ଏବଂ ଯୋଉ ଡିସିସନ ଟା ହେଲା ସେ ଠିକ ଲେଖା ହେଲା ଯେ ସ୍ତ୍ରୀ ଯିବ ବାପ ଘରେ ରହିବ ଇଏ ଯିବ ଭୁବନେଶ୍ୱରରେ ମଝିରେ ମଝିରେ ଆସିବ ଦେଖା କରିବ ତାପରେ ଘର ଠିକ ହେଇଗଲେ ତାକୁ ନେଇକିନି ଭୁବନେଶ୍ୱର ଯିବ ଏହା ହେଲା କଥା ତାପରେ ସେ ଯାଇ ରହୁଥିଲେ ଏକାଠି ଏବଂ ଯୋଉ ଦିନଠୁ ଡିସିସନ ହେଲା ଯୋଉ ଦିନ ଡିସିଜଡ ମଲା ତା ଭିତରେ ଏଇ ଯୋଉ ପାଖାପାଖି 3 ମାସ ତା ଭିତରେ ଯଦି କିଛି ମ୍ୟାଟେରିଆଲ ନାହିଁ ଯେ କୌଣସି ପ୍ରକାର ନିର୍ଯାତନା ହଉଥିଲା ତାକୁ that too in connection with ସେ ଯୋଉ ସୁନା ଚେନ୍ ବା ଯାହା ହଉ then how you satisfy that ମାନେ ଆଉ କିଏ ତାଙ୍କ ଫ୍ୟାମିଲି ମେମ୍ବର କିଏ ଏକ୍ସାମ ନେଇଛନ୍ତି
PW10 ମିଲର ଭଣଜା
କଣ କହୁଛି
May I read my lord?
yes
I know the accused person in the dock and deceased Minati 4 years back. In the month of Asada, marriage between accused Bhanu and Minati was solemnized. After marriage, when Minati was coming to her father's house, she was telling me that she was being tortured by in her husband's house as the gold chain was not given. Her husband, her father-in-law, mother-in-law, and her husband was also assaulting her for other reasons. We were leaving her in her husband's house after pacifying the matter. Again, she was coming and telling us that she was being assaulted, and I had gone to her husband's house at Rotipur. On 2-3 occasions after my departure from husband's house, she was being scolded by the family members of her husband. One year, 4 months after her marriage, Minati died. Cross-examination. It is not a fact that I have not stated to the IO that Minati was being tortured for the gold chain. I was examined by the police 2 months after death of Minati.
gold chain ପାଇଁ ଇଏ କହିବା କଥା ସବୁ କହିନି ପୋଲିସ ପାଖରେ ପ୍ରମାଣ ହେଇଛି ତାକୁ ସେ notified କହିଲା has it been proved through the PW କେତେ ନମ୍ବର ସାକ୍ଷୀ 10 ଅଛି 65 PW10 Anupama Mahanti has not stated before me that Minati was being tortured for gold chain ଅଛି So, as it appears from the evidence of this doctor, even if it is stated that the death was an unnatural death, that one of such ingredients is fulfilled.
Yes.
Hala? But unless the other ingredients are satisfied, 7 ବର୍ଷ ଭିତରେ ହେଇଛି ସେଟା satisfied, unnatural death ହେଇଛି satisfied. But the other things are required to be proved that torture or cruelty in connection with demand of dowry, and that too soon before the death. ହେଲା ତେଣୁ ଏଠି ଆପଣଙ୍କ ତରଫରୁ ଯେତିକ ଲେଟର ଲେଖା ପ୍ରମାଣିତ ହେଲା ଓରାଲ ଏଭିଡେନ୍ସ ପରେ ଆସିବା ସେଇଥିରୁ କେବଳ ଗୋଟିଏ ଲେଟର ଛଡା ଆଉ ସବୁ ଇଏରେ କିଛି ନାହିଁ ରାଦର ଦେଖଉଛି ଯେ ଆଙ୍କ ସମ୍ପର୍କ ଭଲ ଥିଲା କାରଣ ସେ ଯୋଉ ଭାବରେ ଆଡ୍ରେସ କରୁଛି ସ୍ନେହର ମିନୁ ସେ ଇଏ ଅନ୍ୟାନ୍ୟ ଜିନିଷ ମୋର ଭୂମିଷ୍ଠ ପ୍ରଣାମ ଦବ ଆଉ ଇଏ କରିବ ଆଉ ତମେ ଏଇଟାକୁ ମୋର ଏଇ ଅସୁବିଧା ହଉଛି ତମେ ଆରେଞ୍ଜ କର ମୁଁ ତାକୁ ସୁଧ ସହ ଫେରେଇ ଦେବି ଯୋଉ ଇଏ ପାଇଁ ମୁଁ ଚାକିରି ପାଇଁ so
15,000.
this cannot be said to be a demand of dowry. It may be that he was asking for some financial help to get the job and PW6 ର ଆପଣଙ୍କର ଯୋଉ ଏଭିଡେନ୍ସ PW6 ଦେଖନ୍ତୁ ପେଜ 44 ରେ ସେଇ ଯୋଉ ଗ୍ରାମ ପଞ୍ଚାୟତରେ ଯୋଉ ଡିସିସନ ପରେ ତାପରେ ସେ ଷ୍ଟ୍ରେଟ ଆୱେ କହୁଛି ଡେଥ୍ ହେଲା ତା ଭିତରେ କଣ ହେଲା କିଛି ନାହିଁ ତାର ଏଭିଡେନ୍ସ after the panchayat meeting accused Bhanu and Minati remained in Ratipur for some days 4 months prior to her death, they were staying in the house of the village Swanso. She died in the month of Ashwina on a Saturday. On that Saturday, Swanso died. How do you satisfy now? IPC
The accused and that deceased were living together in a house, both of them. And
deceased died an unnatural death.
Yes.
That also is proved.
Yes.
Okay.
At the time of death, the accused is present in that house.
No, he has already been acquitted of the charge under 302. There is no challenge to that. ବର୍ତ୍ତମାନ ହଉଛି ଆମେ ଯୋଉ ଅଫେନ୍ସ କୁ ଧରିଛୁ ଦିଟା ଅଫେନ୍ସ ବର୍ତ୍ତମାନ 304B ଟା ପ୍ରମାଣ ହଉଛି କି ନାଇଁ ଆମକୁ ଦେଖିବାକୁ ପଡିବ ହେଲା 304B where the death of a woman is caused by any burn or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand of dowry or dowry, such death shall be called as dowry death, and such husband and relative shall be deemed to have caused her death. And dowry definition is that section 2 of the dowry provisions, right?
Yes.
ତେଣୁ ଏଠି ଆପଣଙ୍କର ଯାହା what we have already discussed that unnatural death is proved 7 years of marriage proved but the other things which are required to be proved that soon before her death and that to cruelty by the husband in connection with demand of dowry those are missing
At page 45 also, the father of the deceased also reports that at about 8 lines from the below, for domestic quarrel, both accused Bhanu and Minati coming from Retifu stayed at Borsimulia.
Hmm. Hmm.
Because of that family quarrel, they are staying at Borsimulia.
ସେଇଟା ଲେଖା ହେଇଛି ନା ତା ଦେହରେ ମଧ୍ୟ ଯେ ତାଙ୍କର ଘରୋଇ ବିବାଦ ଯୋଗୁ ଇଏ ହଉଛି not at times also visiting back at the inquest also. ଆଉ କଣ କହିବେ? What is your good name, learned counsel?
Mohammad Faradish.
ତାଙ୍କୁ
Lower court basing on Exhibit 4 convicted this in 304.
Exhibit 4.
Yes, that letter written by the deceased to her father.
अच्छा ଆଉ ଥରେ ସେ letter ଟାକୁ ଆସିଲେ exhibit 4 ଟାକୁ ଦେଖନ୍ତୁ. What is the date of that letter? First tell me. ଯୋଉ letter ଟାକୁ ଆପଣ ଏତେ rely କରୁଛନ୍ତି ମୁଁ ଡେଟ୍ ପାଉନି ସେ letter.
ସେଇଟା ଲେଖା ହେଇନି ଡେଟ୍ କିଛି.
ଠିକ ହଁ
ନା ସେଇଟା ନୁହେଁ.
ସେଟା ହଉଛି ସେ ଆଙ୍କର ଜଜଙ୍କର ସିଗ୍ନେଚର SDGM ପାଖରେ ଯୋଉ ପ୍ଲେସ୍ ହେଇଛି ତାଙ୍କର ଆଉ ପୂଜନୀୟ ବାପା ମୋର ଭୂମିଷ୍ଠ ପ୍ରଣାମ ଗ୍ରହଣ କରିବ ଲେଖିବାର କାରଣ ହେଇକି ମୁଁ 8 ଦିନ ହେଲା ବିଲକୁ ଯାଉଛି ମତେ ଶୁଣନ୍ତୁ କରୁଛନ୍ତି
28/97 ସେଇଟା
କୋଉଟା
ସେଇ ଲେଟରଟା
କେମିତି ଜାଣିଲେ
reflected in the judgment.
କୋଉଠୁ ପାଇଲା ସେ
Page 15 million of the judgment.
ନାଇଁ ଲେଟର କୋଉଠୁ ପାଇଲେ ମୁଁ
ସେଇଟା କୋଉଠୁ ମୁଁ ଜାଣିନି ସେ କୋଉଠୁ ପାଇଲେ
କଣ ମନୁ ଯାହା କହିବେ ଆପଣ ସାମ୍ନାରେ ତ ଲେଟର ଅଛି ନା
yes it is.
ଏଇ ଯେ ଆଉ ଥରେ ଦେଲେ
In that letter, there is
Hmm?
husband. Nothing was written about husband. Who is assaulting also not there.
No, it's not
ଅଛି,
written.
ଅଛି.
Husband
ଲେଖା
ର
ହେଇଛି.
କଣଟା
28/97
28
97
28/97
ଦେଖିଲେ ସେଟା ଆଇଲେ some kind of overwriting is there 8 ଟାକୁ ମାର୍କ କରନ୍ତୁ ତାପରେ Okay, Mr. ନାଇଁ ଆପଣ ଆଉ ଥରେ ଯାଆନ୍ତୁ ଲେଟରଟା let us say accept it 20/97 ରେ ଏ
Yes.
ଚିଠିରେ ଯୌତୁକ ବିଷୟରେ କିଛି ଲେଖା ହଉଛି
ନା
ହଁ
ଏଇଟା
so
ନାହିଁ।
that may be 498 ହେଇପାରେ
ନା।
so 498 we are not on 498 we are on that
304
304B
ସେ ବିଷୟରେ ନା
ହଁ 498 ପ୍ରମାଣ ହେଇଗଲେ ବି ଯେ 304B ହେଇଯିବ that's not unless he that in so ସେ ଯୋଉ କହୁଛନ୍ତି 20/97 ର ଚିଠିଟା ବୋଲି କୋଉଟା ସେଟା
ଏକ୍ଜିକ୍ୟୁଟିଭ 4
ନାଇଁ ଯୋଉ ଫାଇଣ୍ଡିଂ ଟ୍ରାଏଲ
finding
Page
15
page 50.
page 15
yes after 3 lines
on 20/97 Minati had written a letter so and so to the father from which revealed that she was being assaulted and thrown to cruelty by It is stated by PWs 1 and 2 in their evidence that in the said meeting, Minati also disclosed that her husband was always assaulting her and the gold chain was not given. এটা କହିଛନ୍ତି 1 number 2 number ସାକ୍ଷୀ କଣ କହିଲେଣି ଆମେ ପରା ପଢିଲୁ ନାଇଁ ପଢି ନାହିଁ
My lord,
yes yes
yes, my
they
lord.
are expected
Yes,
we convened a meeting so
Only-
and so to settle the dispute.
only one had said.
In
PW1.
that meeting, deceased Minati told her that she had brought gold necklace or her husband's father was all as she had not achieved. Okay, accused Bhanu attended the meeting. We asked Bhanu that he should not assault his wife and that difference were compromised. In that meeting, 15 days, received the information so and so. It's not a fact that I have not stated so and so told you. এটা ফার্স্ট টাইম কହୁଛି ମିଷ୍ଟର ତ୍ରିପାଠୀ
yes
ଏଇ ଯୋଉ ଲାଇନଟା ନା ଏଇଟା ପ୍ରଥମ ଥର ପାଇଁ କୋର୍ଟରେ କହୁଛି ଏବେ 161 ନାହିଁ ସେ ଷ୍ଟେଟମେଣ୍ଟ ଆଇଓ ପ୍ରମାଣିତ କରୁଛି ଏଇଟା confrontational in paragraph 4 cross examination. It's not a fact that I have not stated to the IO that deceased Minati told before the punch that she was being assaulted by her husband as she had not brought gold necklace from her father's house. Hala? It
yes
is not a fact. Now you come to the IO's evidence.
para 6
IO ହେଲା କେତେ number ସାକି?
pw
14.
14
PW 14.
para 6 ରେ କହୁ
PW Swans was not stated before me. Swans. So
ଆଉ କେହି ଗୋଲ୍ଡ ଚେନ୍ କଥା କିଛି କହୁ
hmm.
ଡିମାଣ୍ଡ ଅଫ୍ ଆହୁରି ନାହିଁ
498 ର conviction ଟା sustain ହବ ये 304 भी acute ହବ ଲେଖନ୍ତୁ CRA number 10 of 2001. The appellant Bhanu Charan Pradhan faced trial in the court of Sessions Judge, Mayurbhanj Baripada in Sessions Trial case number 78 of 1998, along with co-accused Basanti Naik and Kailash Chandra Naik for offences punishable under section 498A by 34 of the Indian Penal Code and 304B by 34 and 302 by 34 of the Indian Penal Code. The London Trial Court by judgment and order dated 2/1/2001 acquitted the co-accused persons Bashanti Naik and Kailash Chandra Naik of all the charges and also acquitted the appellant of the charge under section 302 of the Indian Penal Code, but found him guilty under section 498A and 304B of the Indian Penal Code and sentenced him to undergo rigorous imprisonment for 7 years for the commission of offense under section 304B of the Indian Penal Code, and rigorous imprisonment for 1 year for the commission of offense under section 498A of the Indian Penal Code. And both the sentences were directed to run concurrently. Stop. The prosecution case, as per the first information report lodged by Ramachandra Mahanti PW6 before the officer in charge of Koptipada police station on 27/9/1997 is that the marriage of his daughter, namely Minati, hereafter the deceased, was solemnized on in the month of Asada 1996 with the appellant. And on account of domestic quarrel, the appellant and the deceased were remaining separately from the other family members of the in-laws of the deceased. In Bodo Simulia Mauja for about 4 months. After constructing a house there. On 27/9/1997, 27/9/1997, the informant PW6 received when I sent message to him that the deceased had died. Hearing such news, PW6 along with his brothers came to village Bodo Simulia and found the deceased was lying dead in the house and the appellant was sitting by her side. When the informant PW6 asked the appellant about the death of the deceased, he told that the deceased consumed poison and died. However, the PW6 suspected that the appellant had killed the deceased after assaulting her. leaving his brothers near the dead body of the deceased. The appellant came, the PW6 came to report the matter in the police station. And on the way, he met the headman of village Bodosimudia, namely Bansidhar Patra bracketed PW1. Who told him that the deceased was being regularly tortured for which he died. It is stated in the FIR that at the time of marriage, as per the demand from the bridegroom's side, all articles, including the gold chain, were given. Including gold chain, all the articles were given. But the demand of gold chain could not be fulfilled, and it was assured to fulfill such demand afterwards. But since it could not be fulfilled, the in-laws family members, including the appellant, were torturing the deceased in connection with such torture. A meeting was convened in the Gram Panchayat on the report submitted on the application submitted by PW6, whereafter the deceased was taken back to her in-laws' house, and thereafter she came to stay with the appellant at Bodosimudia. It is stated that the appellant used to assault the deceased, and sometimes his family members also came to visit him. And on 28/19/97, the deceased had written a letter to the informant in connection with the assault made by the appellant. It is further stated that on account of demand of gold chain, the appellant and his family members subjected the deceased to cruelty and harassment, and being unable to bear the torture, the deceased consumed poison. On the basis of such a written report presented by PW6, Koptipada PS case number 91 dated 27/9/1997 was registered under section 498A 304B 302 of the Indian Penal Code and section 4 of Dowry Prohibition Act. PW14, the officer in charge of Koptipada police station, after registration of the first information report, took up investigation of the case. And during course of investigation, he examined the informant and other witnesses, issued requisition for deputation of a magistrate to remain present at the time of inquest, visited the spot and prepared the spot map exhibit 17, and he also seized sample earth and vomiting soaked earth as per seizure list exhibit 15. The appellant was arrested on 28/9/1997, and one letter written by the deceased to her father and dated 20/8/97, a list of articles given at the time of marriage, and a Panchayat Patra of Pedagudi Gram Panchayat dated 1/6/1997 were seized as per seizure list exhibit 13. The IO also seized the dowry articles from the house of the appellant as per seizure list exhibit 11 and released those articles in favor of PW6. After executing Zimanama exhibit 18. The inquest over the dead body was held and it was sent for post-mortem examination. The ornaments of the deceased were seized and those were also released in favor of PW6. The dead body was sent for post-mortem examination. Some letters were seized. And then the appellant was forwarded to court. The wearing apparels of the deceased and command certificates were seized. apart from other documents. The exhibits were sent for chemical analysis through SDGM Udala, TO2, SFSL Rasulgarh. And since the co-accused persons could not be traced, on completion of investigation, charge sheet was submitted against the accused persons, including the appellant. In order to prove its case, the prosecution examined exhibit list the London trial court, after analyzing the evidence, oral evidence as well as documentary evidence on record, came to hold that from the evidence of the doctor PW13 and postmortem examination report exhibit 16, it is clear that the death of the deceased Minoti had occurred otherwise than under normal circumstances within 7 years of marriage. It was further held that soon before the death of the deceased, she was subjected to cruelty and harassment by the appellant in connection with demand of dowry. The London trial court did not place any reliance on the defense plea that at the time of occurrence he had gone to the house of PW7 to work as a laborer and that he was not present in the company of the deceased, and accordingly found the appellant guilty under section 498A 304B of the Indian Penal Code, while acquitting him under section 302 of the Indian Penal Code and the co-accused persons of all the charges. Stop. The Swansol and counsel appearing for the appellant contended that the London trial court seems to have relied upon letters which are either written by the appellant to the deceased or by the deceased to PW6 and the Panchayat Patra marked as Exhibit 10. But and a plain reading of the contents of those documents would reveal that whatever quarrel was there between the deceased was between the deceased and her in-laws family members on account of the domestic quarrel was there, and there was nothing in those documents that in connection with the demand of gold necklace there was any torture on the deceased, that too by the appellant. Land Council further submitted that in view of the evidence of PW7, it appears that the appellant was not present in the company of the deceased when the occurrence in question took place. The Land Council further submits that there is lack of evidence that soon before the death of the deceased, she was subjected to physical and mental cruelty in connection with demand of dowry, which is one of the ingredients to be proved for the offense under section 304B of the Indian Penal Code. And therefore, even though the prosecution has proved that the deceased died within 7 years of marriage and her death was otherwise than under normal circumstances, but the same cannot be sufficient to establish the charge under section 304B of the Indian Penal Code. The Land Council further argued that from the contents of the letters, it would appear that there was cordial relationship between the parties, and there was no torture given by the appellant to the deceased, and therefore the offense under section 498A of the Indian Penal Code would not also be attracted, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Tripathi led an additional standing counsel for the state, on the other hand, supported the impugned judgment and submitted that the deceased was staying alone with the appellant at the relevant point of time, and the doctor bracket PW13 has noticed number of injuries on different parts of the body, including the fracture of the hyoid bone, and the cause of death has been opined to be asphyxia as a result of compression of air passage in the throat, which was sufficient in ordinary course to cause death. And the deceased and the appellant has not discharged his burden of proof as to how, in his absence in the house of PW7, the deceased sustained those injuries and how she was strangulated to death. The Land Council submits that the letter which was been marked as exhibit. Should I get the number later? Did you
Exhibit 4.
4.
Yes.
Exhibit 4 address to the address address to PW6 by the deceased, comma. It is clearly mentioned how she was subjected to torture by the appellant, and therefore the London trial court was quite justified in convicting the appellants under section 304B and 498A of the Indian Penal Code. Adverting to the contentions raised by the Land Council for the respective parties, there is no dispute that in order to make out a case under section 304B of the Indian Penal Code, the prosecution is required to prove the following ingredients. Number 1, Roman 1 to that the death of the deceased was otherwise than under normal circumstances. Number 2, that the death took place within 7 years of marriage. Number 3, that soon before her death, the deceased was subjected to cruelty or harassment. Number Roman 4, that such cruelty or harassment was in connection with demand for dowry. Keeping in view the ingredients of the offenses, if I analyze the evidence of the doctor PW 13 who conducted post-mortem examination over the dead body of the deceased on 28/9/1997, it appears that he noticed multiple crescentic marks on the left angle of the mandible, multiple abrasions on the nape of the neck, contusion over the larynx, fracture of hyoid bone at its right corner, multiple abrasions on the medial aspect of the left thigh, and the injuries were opined to be antemortem in nature, and death was caused due to asphyxia as a result of compression of the air passage in the throat, which are sufficient in ordinary course of nature to cause death. The doctor's evidence has almost remained unchallenged in the cross-examination. The post-mortem examination report has been marked as Exhibit 16. In view of the evidence of PW 13 and Exhibit 16, the London trial court came to the conclusion that the death of the deceased Minati had occurred otherwise than under the normal circumstances within 7 years of marriage. I am of the humble view that the London trial court has rightly arrived at such conclusion. Stop. Though a plea was taken though it was told to PW6 by the appellant that the deceased died taking poison, but the viscera report indicates that common insecticidal, alkaloidal, and metallic poison could not be detected in the viscera. এটা ତା ପୂର୍ବରୁ ଲେଖିଲା ପରେ conclusion arrive କରିବ that you accept the ହେଲା the prosecution case is that the marriage of the deceased was solemnized with the appellant in the month of Ashada 1996, and she died unnatural death on 27/8/1997. Thus, the requirement of one of the requirements of the section 304B of the Indian Penal Code, that the death should occur within 7 years of the marriage, is also satisfied in this case. PW6, who is the father of the deceased, is the star witness on behalf of the prosecution. And he has stated that at the time of marriage, he had given cash of ₹7,000 and other household articles. But it was decided to give a gold chain at a later stage, which he could not fulfill due to his poverty. For which the deceased was subjected to cruelty. It is further stated that on account of the dispute, he submitted an application before Pedagodi Gram Panchayat to settle the dispute. And in the meeting the Gram Panchayat, of the Gram Panchayat, the appellant was told not to ill-treat the deceased, and an agreement was written. And after Panchayat meeting, the appellant and the deceased remained at Ratipur for some days. And 4 months prior to the death of the deceased, they were staying in a house in village Bodo Simulia. PW6 proved some of the letters as well as the application made by him before the Panchayat and the Panchayat Patra. However, he admits in the cross-examination that in the letter marked as exhibit, there is no mention regarding demand of gold chain by the appellant. And in exhibit 9, there was no mention that for gold chain, the deceased was being tortured. In exhibit 10 also, this fact didn't find place. He further stated that in exhibit 8, the appellant had requested to give him rupees 15,000 for his service and that he would repay the same. And that exhibit 6 contained the household affairs. He further stated that for domestic quarrel, both the appellant and the deceased were coming from Ratipur and came from Ratipur and stayed at Bada Simulia. And at times, they were visiting his house and coming back to Bada Simulia. I've carefully gone through the exhibit 5, 6, 7, 8, 9, and 10. And I'd find that there is nothing written against the appellant's conduct. Rather, it shows a cordial relationship between the appellant and the deceased and the appellant and her in-laws family members. The appellant had requested PW6 in a letter by the exhibit 8, which was addressed to the deceased, to give him rupees 15,000 for his service, which he would repay at a later point of time. And this request of money cannot come within the definition of dowry. As per section 2 of the Dowry Prohibition Act. However, exhibit 4 is a letter which was addressed to PW6 by the deceased, in which it is mentioned how exhibit 4 ta she was compelled by the appellant to go to work in the field and false allegation was labeled against her for selling rice And no medicine was given to him, even though she was having blood in the stool for 3 to 4 days. This letter is dated 28, 1997, which is a week prior to the death of the deceased. But in that letter also, there is no mention of any demand of dowry, particularly that she was subjected to torture by the appellant in connection with demand of gold necklace. PW 10 PW 10 ना जो PW 6 छोड़ा जो आउडे जो
My
घर
lord.
लोग हाँ
My lord. No, my lord,
हाँ
not Bhonaja, my lord.
किस ये
See,
पढ़ी थी
Minati
हाँ
is the
PW
sister of
10
my husband.
हाँ PW 10
Minati is the sister of my husband.
sister of my
Husband. She's a lady. Anupama.
कोड़ी सेटा कोची sister of my husband
My lord, para 2 of the cross examination, my lord. Last second line.
Minati is the sister of my husband. So that means he's the sister-in-law.
Sister.
All right. PW10, the sister-in-law of the deceased, has stated that that the deceased was telling her that she was being tortured in her husband's house, as the gold chain was not given. It has been confronted to PW 10 by the Land and Defense Council and proved through the IO bracket ray PW 14 that she has not stated in the 161 CRPC statement about the deceased being tortured for gold chain. PW1 though stated that the deceased told before the punch that she was being assaulted by the appellant as she had not brought gold necklace from her father's house. But the Land and Defense Council has confronted the previous statement made by PW1 before police, and it has been proved through the IO bracket PW 14 that he has not stated so before the police. Similarly, though PW 8 has stated that there was a talk that a gold chain would be given later to the appellant that at the time of marriage. There was a talk that's one so, but it has been confronted to him and proved to the IO that he has not made any such statement before police. PW 9, though stated that a gold chain was to be given to the appellant at a later point of time, that at the time of the marriage, there was a talk that's one so. Like PW 8, it has also been confronted to him and proved to the IO that he has not made any such statement before police. Therefore, the evidence is lacking that a gold necklace was demanded from the side of the bridegroom, and such demand was not fulfilled, and in connection with such demand there was torture to the deceased by the appellant. In absence of any clinching material on record, that soon before the death, the deceased was subjected to torture or cruelty, or harassment by the appellant in connection with any demand of dowry, I am of the view that even though the prosecution has proved that the deceased died within 7 years of her marriage and her death was otherwise than under normal circumstances, but the ingredients of the offenses under section 304B of the Indian Penal Code are not satisfied. Accordingly, the conviction of the appellant under section 304B of the Indian Penal Code is hereby set aside. So far as the offense under section 498A of the Indian Penal Code is concerned, not only the witnesses but also the later by Exhibit 4, which was written 1 week prior to the death of the deceased, clearly indicates regarding the cruelty on the deceased. The definition of cruelty, as mentioned under the explanation to section 498A, are as follows. Quote this A and B. In my humble view, the overact committed by the appellant to the deceased would squarely come within the explanation bracketry small a, as enumerated under section 498A of the Indian Penal Code. Therefore, the London Trial Court has rightly found the appellant guilty under section 498A of the Indian Penal Code. The sentence passed under section 498A of the Indian Penal Code is quite justified. In the result, the criminal appeal is allowed in part. The conviction of the appellant under section 304B of the Indian Penal Code is hereby set aside. The conviction of the appellant under section 498A of the Indian Penal Code and the sentence passed thereunder by the London Trial Court stands confirmed. You are on bail or you are
My lord, on bail, my lord.
okay? During trial, you
My lord,
you are taken into custody for what period? Vishnu, acha. 28/9/97 when you were released on bail. Have you got any idea?
my lord. After conviction, he was around 6 months, 10 days.
Wait. Yeah, by Vishnu so and so. Okay. No, he was in custody, in judicial custody. Okay, he was released on bail on 17/6/1998, and then he was taken into custody on the date of judgment,
My lord.
that is on 2/1/2001.
2000.
And when he was granted bail by this court,
11 July 2001.
let us see that a criminal appeal over from. Order sheet 11
July 2001.
So and so, so and so. Yes, you are right. 11 July 2001. तामाने आपनकर हला 6 मास एठी आसीगला आउ एटा हेगलानी आपनकर 2897 बेले ये हला 3 मास 4 मास एंड ये होची पाखापाखी 6 मास 10 months 16 so 16 मास हेगलानी. So you have already undergone. Lekon the appellant was taken into judicial custody on 28/9/1997 and he was directed to be released on bail by the London Trial Court on 17/6/1998. Huh? Kuda? Honda. 3 number order. 17 6 ले पूरा ट्रायल कोर्ट रेकॉर्ड बार करो देख कौन 1/5/98 बेर पूरा कैलाश आ मंजुलता 17/6/98 it is Vishnu Charan Pradhan. And after the pronouncement of the judgment लिखिले तो 28/97 रे अरेस्ट हला जुडिशियल कस्टडी निया गला 17/6/98 रे बेल हला and after the pronouncement of the judgment he was taken again to the judicial custody on 2/1/2001 and he was released on bail by this court on by the order dated 11/7/2001 11/7/2001 है and as such he has already undergone the sentence of 1 year as imposed by the London Trial Court which was confirmed today. Therefore, he shall not be taken into custody anymore in connection with this case. Just put a note of appreciation on the London Council for the appellant. हाँ नहीं आपण माने रहिबा को पड़िबे तो कमिंग वीक रे आसीबो ना तो देखिबा कमिंग वीक से बेले बेले आसुनांती नहीं सप्लीमेंटरी आनी परिबेनी बेले बेले के रहू नांती सेतिक बेले कहि देबे थरे पार्टाड हे गेला माने ऊपर पड़े आसी पार्टाड हे जाय आपण 6 4 रे देखिबे ऑर्डर देखिबे जदी हेथिबो पार्टाड देख